a definition, meaning that the life of the mother exception that was entered into the bill is now uses the term serious, that causes a serious health risk, which is, by definition in the statute, the serious risk of substantial and irreversible physical impairment of a major bodily function. These terms does not include psychological or emotional conditions. It's a medical condition which may not be determined to exist based on a claim or diagnosis that the woman will engage in conduct that she intends to result in her death or in physical harm. The pregnancy is a result of rape or incest so long as the abortion occurs during the first 10 post-fertilization weeks of pregnancy, or the unborn child suffers from a lethal fetal anomaly so long as the abortion occurs prior to a viability or 20 post-fertilization weeks of pregnancy, whichever is earlier. That is a change. Lethal fetal anomaly is defined as a fetal condition diagnosed before birth that, if the pregnancy results in a live birth, will with reasonable certainty result in the death of the child not more than 3 months after the child's birth. The bill as it stands requires all abortions to be performed at a hospital or ambulatory surgical center owned by a hospital. Abortions can be done at an ambulatory surgical center only prior to viability or 20 post-fertilization weeks of pregnancy, whichever is earlier. Under this provision, there would be no more abortion clinics in Indiana. It maintains the current criminal penalty in Indiana law for doctors who perform illegal abortions, and it strengthens the civil penalty. That's the law as it stands right now. The doctor may be charged with a level 5 felony. Medical licensing board must revoke the doctor's license if an investigation by the Attorney General demonstrates by a preponderance of the evidence that the abortion was illegal. Under existing law, the board may revoke the license but does not have to do so. It includes language ensuring a woman who gets an abortion is not subject to any criminal penalties. That's what the law says now. It also creates an 11-member prosecutorial oversight task force to make recommendations to the General Assembly on appropriate methods of enforcing statutes if a prosecutor has makes a blanket statement or refusal to do so. The task force must make its recommendations by December 1st of 2020. Requires abortion providers to report the reason for each abortion to be performed. Requires the Indiana Department of Health to issue abortion reports quarterly instead of the current annual requirement. Requires the statewide Maternal Mortality Review Committee to study how changes in the abortion laws affect maternal mortality. Includes language specifying that the bill does not apply to in vitro fertilization. That's the bill as it comes back to us, and I'm urging your passage.
Is there discussion? Senator Taylor. Senator Taylor to question Senator Glick. Do you yield?
Yes.
Senator Taylor.
Thank you, Madam President, for allowing me to, and thank you, Senator Glick, for agreeing to answer my questions. Senator Glick, I know it's been a tough couple of weeks for all of us, but this bill started out as giving children under the age of 16 12 weeks to make the decision as to whether or not to seek an abortion if they're the victim of rape or incest. Correct me if I'm wrong, this current version, which you are asking us to support, gives them even less time.
It has had several ideations, if you recall. It was amended to say that children under 15 and under would have 12 weeks, and individuals 16 and over would have 8 weeks in the case of rape and incest.
Yes.
As it comes back to us from the House of Representatives, it is now 10 weeks across the board.
Right, so children under the age of 16 now get less time under this bill,
Yes,
and you're okay with that?
yes.
If I remember correctly, during discussions on this floor, there were some questions about whether or not 12 weeks was enough time for a child to realize they were pregnant. Now you're saying that, correct me if I'm wrong here, that even someone under the age of 16 needs even less than 12 weeks to determine if they're pregnant or not.
I think the determination of pregnancy can be made. The question becomes when they discover that they're pregnant.
Right.
And also we have to factor in the concept of if this is a threat to the life of the mother.
Not in the rape or incest, correct me if I'm wrong. I'm not trying to tell you how to read your bill, but that has nothing to do with the fetal anomaly or the life or the health of the mother is irrelevant. This is in the case of rape or incest. That's all I want to focus on right now.
Well, I understand, but you can't ignore the language of the bill where it says serious health risk to prevent death or serious health risk of, or serious risk of substantial and irreversible physical impairment of a major bodily function. So if it's a young person who would die or be, have a serious health risk, they still fall under that exception. Well, serious health risk doesn't go away just because they were raped or it was a case of incest.
I agree. You brought up serious health risk, so now I'll ask you about that. Do you look at the definition of serious health risk in the statute?
That's a recognized definition under Indiana statute. We just incorporated it.
Yeah, are you familiar with that definition?
As it's set forth, yes.
So you do understand that in that definition that the term does not include psychological or emotional conditions?
Yes.
So you're saying that the fallback for these younger than 16 children, say a 10-year-old, is just their physical body, not the emotional or psychological part of having a child before the age of 16 is okay with you?
There is an exception if it's within that 10-week period. They can have an abortion for a termination of their pregnancy for whatever reason under that 10-week period. If it's beyond the 10 weeks and they have a serious health risk, the abortion is not banned at that point. It can be considered if there's a serious health risk.
Senator Glick, I understand that, and I'm trying to understand so you've related the two. I'm trying to exclude the two.
I know, but I don't think you can, Senator Taylor.
Well, if you want to keep them together, then let's keep them together. But here's the question I have. For a 16-year-old to have a child, younger than 16, let's make that clear, to have a child, and then the only option, let's say they're not the victim of rape or incest, which is another thing I'll bring up in a second, but you're saying that they're emotional, by our definition of serious health risk, their emotional or psychological condition is irrelevant. Do you understand that?
Yes.
Okay. So no matter what the psychological or emotional effect of having a child when you're younger than 16 is, we're going to disregard it in Indiana. Now, if they are the victim of rape or incest, then they have 10 weeks. Otherwise, they must have the child, the child, right?
Unless the doctors determine if there's a serious health risk to prevent death.
It doesn't have to be death. Am I correct?
Or a serious risk of substantial and irreversible physical impairment of a major bodily function.
Right. So it has to damage her body. Forget the damage to her mind or her emotion. It's just her body that we're worried about.
We have it in the statute both ways to cover the problem.
You have it to cover psychological or emotional conditions?
In this bill, she has until she's, the individuals who are involved in the decision-making, because if she's younger than 16, if she's 15 or younger, she's going to have the assistance of others in regard to this. They can go to court. The doctor can recommend that they go in front of the statute still is there. That was not changed by this bill, where they can go to the juvenile court for permission or consent to have an abortion for these reasons. They can still go to the court.
For what reasons?
For the reasons set forth in the bill.
And so you keep bringing up these things. I'm trying to, how long is it taking them to get into court?
It would be one of those items that would take precedent over anything else in the court.
So they would get an emergency hearing?
Absolutely.
Okay, so you're saying that the juvenile, even if they disagree with their parent, and they want to pursue this abortion, they can do that?
If a child presents as pregnant under 15, then the court or the physician or healthcare facility must report under our laws, because that is a crime. And so then it becomes the business of the court, and an adult can take them forward to the court can intervene, because you have family members involved if it's a case of incest. But by definition.
Right, and by definition, rape. We'll get to that in a second. So again, going back to what I asked you, the definition of serious health risk in our Indiana code excludes emotional and psychological conditions. Therefore, the young person who is attempting to fall under this exception cannot bring up psychological or emotional conditions. Yes or no?
No.
Thank you. Now, let's talk about this standard that the attorney, well, the Attorney General is the one who would pursue these cases.
Against the doctors or the healthcare providers, yes.
Okay. And you brought this, you used this term of art, preponderance of the evidence.
Yes.
Now, I want to, I know you're an attorney, so where in the hierarchy of evidence is preponderance of the evidence?
The highest standard would be beyond a reasonable doubt. The next highest standard would be preponderance, and then, you know, as we go, I mean, you know, you
so
know that you're an attorney.
Preponderance is in the middle,
yeah.
Right?
Right.
And this Attorney General would have to prove by more than 51%. That's how we look at it.
Any Attorney General. Todd Rokita will not be the Attorney General of Indiana forever.
I didn't ask.
I know where you're going, Senator Taylor. I was just trying to help you get there.
But I can only deal with what we have in front of us.
I understand,
and right now,
but I was just trying to assist. I apologize.
We have an Attorney General who is actually pursuing a doctor. So I think it's very important to bring it up right now. Now, if he has to prove by the preponderance of the evidence standard, which is in the middle, this is the taking of someone's license. Am I correct?
Correct.
And you're depriving them of their property using the middle standard and not the highest standard.
That's current law. And that's current law in front of the presence of the Attorney General in this is because the Professional Licensing Board already has the Attorney General in regard to the prosecution of these cases to prove that they're by preponderance and evidence that they should have their license removed. There are other professional licensing situations that come before these boards, and the Attorney General fills that role throughout the statutes. This is not the only statute that the Attorney General office is involved as the individual who prosecutes these cases.
I thought that this bill would allow the Attorney General exclusive of the medical licensing board to take their license.
No, he has to go before the medical licensing board.
And we establish in statute the standard
That's
that
the
he has.
statute now.
Right, I understand. So he has to go and prove in front, and then they take his license. Now, as far as
They
the criminal,
may or they may not, but if they prove it, then they shall. That was a change in the bill.
that's what I thought. It shall. It doesn't say that they have the discretion. You just answered my next question. In the prior
I'm
statute,
trying to help, Senator.
yeah, I don't know, but in the prior statute, they had the option. This is a mandatory.
May was in the statute, yes.
This is a mandatory shall revoke.
Yes.
So these medical professionals, just so I understand, are now going to have to listen to our Attorney General, and if our Attorney General proves by one of the lower standards that this doctor provided, that medical licensing board has no choice but to take that person's license.
I believe, Senator Taylor, that there are protections in this under the framework that we are now requiring under the statute that these operations or these abortions be conducted in hospitals or ambulatory surgical centers, which are in fact affiliated with the hospitals. And each of those hospitals are going to have protocols in place. They will not let their healthcare providers operate in a vacuum. They're going to have extensive protocols as to what they can do and cannot do. Doctors do not get reimbursed. They do not have the option of just performing surgeries at will. They have to follow standard protocols, and there will be stopgaps in the processes in front of these hospitals and these ambulatory surgical centers. And we have to rely too on the hospitals instituting their requirements over the individuals that they're paying or a part of their professional conduct standards within those hospitals and those various facilities. That was one of the reasons that we went to hospitals and ambulatory surgical centers.
I didn't ask about that, but okay. Why change the word from may to shall?
That was the will of the majority.
Is it your will today?
Yes.
Okay. So you want the Attorney General to now usurp the authority of the medical licensing board. Is there any other profession you'd like to give him the ability to make the decision for the professional licensing?
I think he has it in other professions. I don't have it, all of those professional
The
licensing.
shall provision because he proved something?
I think he has control. The standard is by preponderance of the evidence.
I'm not
That's
arguing
what's
that.
in the statute.
But you changed it. This changes it to a shall provision.
This
Senator,
came back to us from the House of Representatives with shall, yes.
Which you know from your extensive understanding of the law is a significant change because it makes it mandatory. And all I'm asking you is, the Attorney General is now seeking the license, as we sit here today, and as of September 15th, if this bill goes into law, that standard will be in place. So no matter what the Professional Licensing Board determines for that physician, whatever the Attorney General approves is the standard, is the decision.
The board has to make that finding.
The Attorney General has to make that finding.
The Attorney General must prove it, but
Right.
the board has to make the finding.
But the board has, if he...
It's not the Attorney General's finding, it is the board's finding.
And what must the board do once they find that the Attorney General has proven beyond a reasonable doubt? I mean, preponderance of
Like
evidence.
any judicial body, they will say shall, and they will revoke the license.
Oh, so when somebody's found guilty, we give mandatory, the court doesn't have a decision, it's a may provision that they can provide a certain sentencing on that.
In some cases, they do, but in this case, they will not.
Exactly. That's what I was talking about. This case, they won't. but in other cases they do. I want to talk to you about the other parts of this legislation that changed when this bill was brought over. The health of the mother has been changed and redefined. Am I correct? From current law.
Yes, the term serious health risk was requested by members of the medical, the medical profession, because it was a term, a definition that they were familiar with and is already in statute. Sometimes when we write legislation, as you know, we're not doctors, we're not physicians, we're not healthcare providers. They have a standard that they use, and that was one they requested that be consistent in the statute so that they knew what they were dealing with. Because as you pointed out, their license is at risk, and so they want to make sure they understand an acceptable definition that is currently in statute that they have worked with in the past.
Okay, so now on page 13 it says that before earlier viability of the fetus or 20 weeks of post-fertilization age, then that's when this serious health week, that's the time period you can use this serious health risk, right? Prior
Correct.
to 20 weeks.
Yes.
Okay.
And the reason for the 20 weeks is that's viability. And there's other provisions in the statute that says if they're going ahead, that another doctor has to be present just for the fetus, just for the child.
Did you just say that 20 weeks is viability?
Yes. That's assumed viability. We don't know what it is. Some babies can survive at 20 weeks, some cannot. It depends on their development.
So then it begs the question, do you believe viability is at 20 weeks?
That's what I'm being told by the statute, yes.
No, this is what you
I didn't rewrite the whole statute.
Senator Glick, I didn't. You just said it's viability.
Yeah.
Are you saying that 20 weeks is viability?
That's what the statute says.
Okay. All right. So the other part of this is the lethal fetal anomaly. And that must be determined prior to 20 weeks as well, right?
Occurs prior to viability or 20 post-fertility weeks, yes, of the pregnancy.
Okay. So do we have a definition of a lethal fetal anomaly in our statute?
It is defined as a fetal condition diagnosed before birth that if the pregnancy results in a live birth will, with reasonable certainty, result in the death of the child not more than 3 months after the child's birth.
Okay.
There's nothing mandatory that says an abortion must be conducted.
I agree.
There's a choice here, and a parent can say, I don't want it, I want to carry the child to term.
There's a choice?
There's a choice.
After 20 weeks, there's a choice?
Yes.
So what does a woman do if she says that she doesn't want to carry the child after 20 weeks?
She has to prove that it fits within these other exceptions, that it causes a serious...
That's all we're talking about is these two exceptions. I think you're maybe misunderstood my question. I asked you about the lethal fetal anomaly. If that was discovered after 20 weeks, what is the option for the mother?
The mother can carry the child to term after 20 weeks, and then the child...
There's no choice.
If it's a serious risk, health risk to the mother, then there is a choice.
I just asked about, okay, let's...
You don't want to talk about all the options. You want to frame it in your reference. I'm just telling you what the bill says.
Well, there are two, and correct me if I'm wrong, you're an attorney too, and as I you look at these are two distinct characteristics in which you could get an abortion prior to 20 weeks. One is the serious health risk, am I correct?
Yes.
One is lethal fatal anomaly, am I correct?
You can,
mutually exclusive. Both of them are mutually, it doesn't say and, it says or.
Correct.
So, I'm not convoluting both. I'm asking about lethal fetal anomaly.
Right.
If that is discovered after 20 weeks, what is the choice of the mother?
To carry the child to term.
So there is no choice.
Correct.
Thank you. That's all. Yeah,
Okay.
you said there was. Okay. All right. There is no choice. The physicians in these surgical centers are going to be required to fill out a document in regards to a person who claims they are the victim of rape or incest. Am I correct?
Yes.
And what is that document going to say?
The person has to disclose that if that's why they're seeking an abortion.
And so they disclose that to the medical profession?
Correct.
Now, that medical professional, once they fill out the documentation that says this person came to me because they were a victim of incest or rape, is there any other provision in here that requires that doctor to pursue criminal or investigatory options?
They're required under the law to disclose it to the, if it's a child, they're required by law to disclose it. It's a crime.
What if they're over 18?
Then that's an option between if it's a confidential disclosure between the patient and the medical person.
So women over the age of 18, just so I understand, women over the age of 18 that claim to their doctor that they're the victim of rape or incest, they don't have the same protection as far as reporting to the authorities as women who are younger than 18. You know that.
They can make that report any time. But only about 35 to 37% of the people who were raped make a report to the authorities. That's a choice they make.
We're not talking about making, I'm glad you brought that up. You keep making it, this is not to the authorities. They're making this claim to a physician.
The physician isn't following up with criminal action.
Right.
The authorities would, but
even
some women will not disclose and will not report because they feel they're victimized twice by the system. That's a choice they make.
I agree.
But with choices, there's consequences.
Yes, there are. And so these 37% of women who won't even report to authorities, now you expect them to report to a physician who can't do anything about it, that they've been the victim of rape or incest.
The doctor needs to know, in most cases, the healthcare provider needs to know if there was a rape or there was incest. From the standpoint, if there are a lot of different medical situations, sexual transmitted diseases, other problems that may be involved in the course of care that need to be noted in the chart of that individual. It's a necessity for them to be treated medically with the best possible outcome. And that's one of the reasons that it's in the chart. They need to have follow-up tests for sexual transmitted diseases on the off chance that it was passed to them. And that's one of the reasons they want it in the chart. The chart is confidential.
But that chart, you're speaking of general situations. I'm speaking of a specific situation where the young woman, the young person is pregnant. That's what we need to focus on. I'm saying to you, that person, if they're younger than 18, that physician is a mandatory reporter, and they must report that to who?
To the doctor. Oh, you mean the doctor's report? They have to report it to the authorities. Normally they have to report it at least as far as the Department of Family and Family and Children or Social Services, whichever the flavor of the month, and they call it this week. But so they have by statute they have reporting requirements.
So here's the scenario, Senator Glick. Now the doctor's going to tell this young lady who's under the age of 18. Who probably is under the care of some other adult, I'm going to report this to the authorities because I have to, right?
He has to report it.
Got to tell her too, right?
I don't know if he has to tell her. I don't think there's any requirement in the statute that he tells a youngster, a 9-year-old, or whatever, that he has got to report it. I think most medical care providers would advise the individual.
Okay, thank you. Yeah, so they're going to tell him, I'm going to go report this to the authorities, and as you said before, and I'm going to victimize you again if you want to seek an abortion.
No, I think the question becomes the safety of the child, because in regard to this, you also get involved with the idea is this child safe from their rapist? Are they safe from a family member who's taken advantage of them sexually? There are other questions involved, and that's one of the reasons the Department of Family and Children is involved in this case, is to protect that child.
Okay.
These requirements were instituted by statute throughout our criminal statutes, throughout the code, to protect the child along the way.
I have no problem with protecting the child, but you even said, what is it, 37% of women actually report rape to the authorities?
Talking about adult women.
Right.
Yes.
So what do you think this is going to have a chilling effect on those reports?
No.
Do you think the young lady is going to sit there and say, yeah, go tell the police because I came here seeking, if she wasn't seeking an abortion.
Now, are we talking about children, or are we talking about adults?
I'm about children.
Children, I think that children have to be protected, Senator, at every step of the way. I think children need to be protected.
Right.
And the medical care provider is going to take every opportunity they have to protect that child.
Okay.
Both medically and legally.
All right. So I'm glad we got that out. So we know that the physician would then have to report if the person is under the age of 18. If the person is over the age of 18, they don't have to report. So the physician could say, you're 8 weeks, you've told me you're the victim of rape, and the physician does not have to report it.
Right.
So the person goes through an abortion, and the rapist.
The opportunity to report for an adult is there all through this.
All right, I just
They can continue, and because they have come in and they've presented, there will be other evidence. If they've reported, quite often the investigation is conducted and the individual ends up going to an emergency room or going to a healthcare facility, and quite often they're offered a morning after pill or something to prevent conception if it was a violent rape, and the investigation can be conducted immediately as opposed to in a delayed fashion, which is what we're talking about.
What if the doctor provides her, let's say she's 10 weeks, and the doctor provides that pill? Is that considered an abortion under this statute?
No, because it's preconception.
Okay, good. It's 10 weeks post-fertilization is preconception. All right.
No, we're not talking, we're talking about that if they report it immediately, they go into the hospital. Don't put words in my mouth. We were talking two different incidents. You know, Senator Taylor, we can stand here all day and you can say, what if? But we feel that we've addressed these issues, and I think the House reviewed the bill that we sent them that passed out of this House with the intent to tighten it up, to make it as protective as possible to the individuals seeking these health care services, and to provide them with the opportunity to make the choice whether they want to continue the pregnancy or they terminate. But there are reasons that we would allow the termination of the pregnancy in these cases.
Yeah, Senator Glick, you have to forgive me. I think it's my right to stand up here and ask you questions.
Absolutely, but we could be here all day if we're going to go under this circumstance or this circumstance or this circumstance or this circumstance. And I'm welcome to do that, But the problem being that we have the face of the bill in front of us. You can read the bill. You're a good lawyer. You can read the bill.
Do you believe that 10 weeks is adequate time for a young person to actually determine whether or not they're pregnant?
I believe that was the amount of time that was agreed to by the majority of the people in the House of Representatives, and we'll determine whether or not the people in the Senate agree.
So I guess you don't. Okay.
Again,
I mean, because you could have just answered it yes.
Well, we'll see what happens here.
So does a vote, let me say this then. So does a vote in favor of this bill, in your opinion, mean that you agree with that 10 weeks is when a woman could determine she's pregnant?
They agree with the majority of what's in this bill, and they want this to be the law in Indiana until it's changed.
Right, so they don't have to agree with the whole thing. It's just certain parts of it that they agree with, and that's why
I have
they would
found
vote.
in the period of time that I've been here that not all 50 people agree with all the contents and the provisions of every single piece of legislation that runs across the desk, even if they vote in favor of it.
Okay, thank you, Senator Glick, for answering my questions.
Further discussion, Senator J.D. Ford. Senator Glick, do you yield? Yes. Senator J.D. Ford.
Thank you, Madam President, members of the Senate. Thank you, Senator Glick, for yielding. I tried to pay attention to the House testimony to try and keep up with the bill, but I just have some questions for you. You said that the life of the mother was defined in statute. Is that correct?
Yes.
Okay. Is it to list all of the medical conditions in the life of the mother statute? Is that possible to do?
You mean the serious health risk issue?
Yes.
That the definition of serious health risk is an accepting medical definition that medical providers or healthcare providers are familiar with and they work with every day.
Okay. Is it possible that the life of the mother could have a condition that might not be listed on that list?
That's why it's not specific to one, certain definitions. I think it's a broader definition of that. And I think when you're approaching this, the healthcare providers that we talked with, they said that is something that one person, unless it's an emergent circumstances, they generally consult with each other and with experts in the field because of the seriousness of these decisions.
So who makes the final decision?
I think they collectively make it, and they make it based on that individual at that location at that time, given all the circumstances.
But isn't it possible that two reasonable physicians can come to different outcomes?
Normally, if that happens, then they search and they find someone else that they can consult with. They don't make these decisions in a vacuum. Generally, they consult with other medical professionals.
Do you think that they would also consult with their legal departments because of the language of the bill?
I think that they probably would consult with their legal departments in advance and have certain guidelines, but I don't see a committee convening in the conference room while they have someone in emergent, extant circumstances.
No, I appreciate you saying that, because that's the concern that I keep hearing from healthcare providers in my district, is that they're worried that some of the language in the bill just isn't specific enough.
And that's why I believe why the change was made in the House is they were trying to tighten up the definition, make it more consistent with what healthcare providers and medical professionals use now as their definitions. Because every time we create a different definition, and lawyers talk different than doctors who talk different than other providers, I think we throw too many different, and they're all subject to interpretation by staying with standard definitions that are used in the industry or in the profession. It's a much tighter definition. It's easier for them to understand.
Gotcha. Kind of going back to the conversation that you had with Senator Taylor, and I'm on page 13, line 41, in terms of the all facts and reasons supporting the certification. So you talk about certification there. On the following page, you talk about the certificate. Can you just talk a little bit about that? Are we talking about the certification and the certificate then being attached to the medical chart? Is that what that's in reference to?
He certifies in writing to the hospital or ambulatory outpatient surgical center that the abortion is being performed in his reasonable medical judgment, that it's necessary to prevent a serious health risk to the pregnant woman or to save the pregnant woman's life, and or the fetus has a diagnosed lethal fetal anomaly. It's basically the steps that he would take, and that's what he would include in the certificate. I assume these certificates will probably be a form, plus there'll be a space for him to say what he based his decisions on.
Is it possible for the Attorney General to subpoena that certificate?
I think that I would assume a good lawyer would want all the information regarding the course of treatment, and so would the Medical Licensing Board. I would think they would want that information.
I hear you, and I think the point that I'm trying to make is that, you know, a doctor doing what he or she thinks is right, following the statute here, signs off on it, but then they know that perhaps maybe, you know, the Attorney General finds out about this, then subpoenas this record, and then we are off to the races in terms of their medical license being terminated. Can you understand and see
Well, and I
potentially...
believe that in any of those cases, the doctors or the medical professionals would have the right to bring forth the support from other medical professionals saying why this was reasonable in terms of the decision that was made and the conditions existing at that time, at that place. Sure. This will be post-operation, this will be post-procedure, and it would be reflective also of medical professionals commenting on the actions that were taken.
But don't you think that's an extra hoop to make healthcare providers jump through with this particular requirement?
It's common in the industry, it's common in healthcare providers to have these types of review.
Okay. My last question for you, and thank you again for yielding. I really appreciate you taking my questions. The last question that I have is that I noticed that the House of Representatives sent over from 9/1 to 9/15, giving folks an additional 2 weeks to kind of get everything situated. Am I reading that correctly?
Yes, okay. And that was requested by the medical professionals. They have reviewed, they would not know what this bill says if it passes until it's printed. Yeah. Then they have to go forward and they have to set their protocols, because the hospitals, the ambulatory surgical centers, all of these groups along the way need to have their protocols in place. And I'm assuming that'll not only be the medical personnel, the medical staff reviewing those protocols, but also their legal staff to make sure they're in compliance. I don't see insurance companies or malpractice providers or anyone else signing off on these until they've had a chance to review them and make sure that they protect their professional providers.
Do you know which healthcare providers asked for that? Because I'm actually hearing something opposite of what you just said, and that the date that they were requesting was November the 1st.
I think that's fair. They would have liked to have had an extended period of time.
So why couldn't we meet them in the middle? Why did we choose an extra 2 weeks? I mean, an extra 2 weeks is not going to be enough time, in my opinion.
They indicated to us that they felt they could have protocols in place in 2 weeks. They didn't think they could, they preferred having it a month or so out. Ideally, they would have preferred it be an extended period out, but when's the right time? And that was the question, and this is a serious matter. We wanted to get it implemented as soon as we could.
Yeah, I understand that, and I think that, you know, giving the extra 2 weeks was appropriate. But I guess what I'm trying to say is that, you know, these folks are going to have to train folks on the new law. They're going to have to educate folks, not just hospitals, but, you know, this law is also going to take effect and affect state agencies as well. And so I guess what I'm trying to say is that I'm not quite sure that providing the extra 2 weeks is going to be enough time for our state agencies, our hospitals, and anybody else that this bill will affect. I mean, can you understand the consternation?
I know what you're saying, okay, Senator, and I appreciate it, but I think the concern is that they can deliver the services, and medical providers are very good about meeting the circumstances, the emergencies that they're faced with on an almost daily basis, and some of the specialists in this area see this much more rapidly, and they know what their protocols are. I think they'll move faster than maybe someone who never sees the situation.
Okay, thank you, Senator Glick.
Thank you, Senator Ford.
Further discussion, Senator Bohacek. Senator Bohacek to question Senator J.D. Ford. Do you yield, Senator Ford? Senator Bohacek.
Thank you, Senator J.D. Ford and Madam President, members of the Senate. Senator Ford, would it be a surprise to you if I told you that 3% of the population in the state of Indiana has an IQ of less than 70?
I'm sorry, can you repeat that?
Would it surprise you if I told you that 3% of the population of Indiana has an IQ of less than 70?
I'm not familiar with that, but I'll take your word that that's the statistic.
Thanks. And so that would equate to about, if we look at just females, that would mean between 80,000 and 55,000 females above the age of 18 would have an IQ below 70. Now, the IQ below 70, I don't know if you know this or not, I'm just going to help you so you can answer the question, is the trigger for what's called mental retardation. So those folks would be eligible to have a guardian. Does that make sense to you?
Sure.
Awesome. So do you see anything in this bill that would allow for women in this situation to be able to receive care if they are raped, assaulted, or otherwise, to receive care after 10 weeks because of their IQ of 70?
Senator Bohacek, I have read this bill as it came over. As I mentioned to Senator Glick, I listened to the testimony yesterday, or whatever day it was, all the days are running through. I did not see that in this bill.
So it would be safe to say that women that are essentially mentally handicapped, some would say retarded, I would say differently, but sub 70 IQ, which is mentally handicapped, would have no ability to be able to receive an abortion after 10 weeks, right?
I think you raise a great point there, Senator Bohacek. The other thing that I'm concerned about are people that are nonverbal, in terms of, people that are on the autistic spectrum. It may be longer than 10 weeks for those folks to figure out that they're pregnant. And so I'm not sure where you're going with this, but I think we're on the same page with this topic.
Asking you a question, okay. Senator Ford.
All right.
Would it surprise you if if I asked you a question that do you think the incidence of sexual assault on women that have IQs sub 70 are over 10 times more likely to be assaulted sexually?
Yes, I did know that statistic. I don't know if you know this, but I worked in the domestic violence, sexual violence space before I came to the Senate. And that statistic is really unconscionable in our state. It really kind of centers this conversation on what we're doing here today. The fact that these folks are vulnerable, the fact that these folks cannot use their voice to express themselves is hard.
Thank you.
Yes, thank you.
Further discussion? Senator Becker. Senator Burrow. Senator Burrow. Senator Becker. Senator Becker is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. I'm sure you're tired of hearing from me, but this is my last chance to speak on a piece of legislation that I feel is very bad for the citizens of the state of Indiana, in particular women. I wanted to share with you, Senator Boots could not be here because he is in Yellowstone, and it was a trip that he had planned a long time ago. But he did send a letter, and I wanted to share. I contacted him today and asked if it would be okay if I read his letter on the floor of the Senate. He said, I'd be happy for you to. He said, I know that this legislation fulfills the desires of a very small majority of our senators, but I am very sad to see it happen. I heard some say in the past that those who govern least govern best. This legislation is the worst attack on the personal freedoms of the citizens of Indiana that I have seen in my 16 years here. I have always tried to vote against government overreach, and this takes the cake. I believe that it is not our duty as legislators to tell people how to live their lives as long as their decisions don't impact those around them. Deciding to have an abortion is a very personal decision and should be made by a woman without interference by the state. Not all faiths and religions agree on when life begins, but it appears that a small majority of mostly male Protestant senators will force everyone in Indiana to believe what they believe and live their lives accordingly. I believe that is government overreach at its worst. I also believe this legislation does not match up the will of our citizens, if you agree with the polls that others have taken. I wish I could be there in person to express my opinions and to vote against this proposal. He was hopeful that we would be in session on Monday and he would be back in town because he had a vacation planned with his wife a long time ago. I also wanted to share with you that I am a representative of my district, and I do my best to try to find out how people in my district actually feel because I want to represent them accordingly. So what I did in the early part of July, and maybe the end of June, part of the end of June, is I sent out a survey to my constituents on my e-news list. And the first question that I asked was, do you agree with the Supreme Court's decision to overturn Roe v. Wade? Well, 7.2%, or 111 people, agreed that they agreed with the overturn. 92.38% said no, they did not agree, and that was 1,346 people that responded. I also asked if they felt like there should be exceptions to legislation banning abortions, and 7.74 said no, 92% said to protect the life of the mother, 90% said in case of rape, 90% said yes in case of incest, and there were 1,408 people that responded. The final question that I asked was, do you think that the decision to have an abortion should remain between a woman and her doctor? And 95.1%, or 1,383 respondents, said yes. And 4.4%, or 65, said no. So I don't know what other polls, I've heard that most statewide polls show that the majority of Hoosiers agree with, maybe not quite as strong as my poll, but mostly. So that's why I have opposed this piece of legislation. I think that we enter into this debate short-sighted with mortality statistics, as I've quoted before, that put us infant mortality 47th in the nation. We have the third highest rate of maternal deaths, twice the national average. I really think we need to fix some of those problems before, because I can tell you right now, you're not going to find providers out there to do those things. This bill will have a negative impact on the health care of Hoosier women who are planning to carry their child to term. And I just think that when you look at the 25, we only have 25 maternal fetal medicine specialists who treat difficult and complicated surgeries and pregnancies. And I just think we're really being very short-sighted. I think we need to consider this topic in a short special session. I don't delude myself to think that this is not going to pass, but it will. And as I quote Senator Boots, this legislation is the worst attack on the personal freedom of the citizens of Indiana that I have seen in my 41 years of service here. Thank you.
Further discussion, Senator Breaux. Senator Breaux is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. I feel as though, I've really said all that really needs to be said about this bill, and as Senator Becker and others have said, we have exhausted it up here. So now I just want to talk about the implications of this bill. We've talked about what it does to a female to have to carry a term to pregnancy, to a pregnancy to term, that she chooses not to do so, and the impact on that child, the impact on that woman, the impact on the family, the impact on the economy. We've talked about all of that, and it hasn't made a difference. So maybe I'll just start with this, and that is that there are just 8 of us in this chamber who have ever had the potential to become pregnant. 8. And yet today, we are poised to tell millions of Hoosier women, many of whom are outside, what they can and cannot do with their bodies. This is an intrusive effort to extend government control into the private lives of Hoosiers, and specifically Hoosier women. It erodes individual rights and freedoms and liberty, something that has long been touted by Republicans, freedom and liberty. Language that has been, in many instances, I've considered your mantra. Freedom, liberty, personal rights. Yet here we are today, poised to strip from women a basic right that has been constitutionally protected for almost 50 years. We are backsliding on democracy. We are creeping dangerously towards autocracy. What other freedoms, what other liberties are on the chopping block, waiting to be stripped away? What other protected rights are awaiting dismantlement? These are scary times, and all Hoosiers should be concerned. We all might recall the quote, it bears repeating. First, they came for the socialist, and I did not speak out because I was not a socialist. Then they came for the trade unionist, and I did not speak out because I was not a trade unionist. Then they came for the Jews, and I did not speak out because I was not a Jew. Then they came for me, and there was no one left to speak. All of us who love freedoms this great country has fought wars to protect should stand together, no matter who we are. Because I fear if we don't rise today and stand with the millions of women who will be directly impacted by this bastardization of public policy making, then we might well see the erosion of even more personal freedoms. Today, I will strongly and passionately vote no. And I urge all, men, women, young, old, black, white, gay, straight, trans, to come together to not only overturn Senate Bill 1, but to support all personal freedoms granted by this great Constitution, and to preserve the democracy, this great free society in which we live. Thank you.
Further discussion, Senator Lannon. Senator Lannon is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. When we passed this bill last week, sent over to the House, I was worried that this bill would come back even worse than when it left here. And so the question is, did it or did it not? Well, I think one thing is absolutely fair to say is that it is in no way an improved bill from what we sent over to the House. I say that because it remains a rights-stripping bill, because just as the Senate bill does, it eliminates a woman's right to control of her own body or the right of a woman in conjunction with her partner to make decisions about family planning once becoming pregnant. It takes those rights away from the person, the individual, and gives them to who? The government. The only choice retained is if she is a victim of rape or incest, and even there, the most vulnerable victim, the youngest victims, those under 16, are now given an even quicker time, taken back from 12 weeks in the Senate version to just 10 weeks before they are forced to have their attacker's child. And I know Senator Glick talked about this serious health risk exception, but really, quite frankly, that is something which I think will chill every physician who has to make that determination. And what, in fact, if you have an 11-year-old, a 12-year-old, a 13-year-old, for which there is no serious health risk that can be made? And if they don't make that decision within 10 weeks, then they're forced to have their attacker's child. It's that clear or simple. Does that seem humane to you? Does that seem compassionate? It doesn't to me. So I say we don't protect the physical or mental health of these young victims who are traumatized, confused, and very possibly even ignorant about what has happened and is happening to them. It's no wonder that the Indy Chamber has called this bill reckless. Now, as regretful that I am that some felt we had to legislate on this matter immediately after the Dobbs decision, which, as I've said before, I believe was very harmful and is very harmful to our country, I'm proud that my last stand in this body has been with others who feel this legislation is an overreach, that it does represent big state government intrusion into the personal rights of a person to choose, to decide, and to control their own body, all of whom in this case are women. It also represents intrusion into the most basic rights of women of childbearing years and their partners, husbands or otherwise, to decide if and when it is the right time to start a family should she become unexpectedly pregnant. So the bottom line is that no matter what else one feels about this legislation, one thing is clear. It removes a right recognized up to this point for generations now, that said this decision, up to 20 weeks post-fertilization, was a personal, private matter free from big government interference. Undoubtedly, this bill, legislated in an overwhelmingly paternalistic environment, done hastily, rejecting medical, scientific, economic evidence, and I believe over the will of the people. I agree with the other senators who have said this is the most obtrusive piece of legislation that this body has passed, certainly in my 25 years serving in this body. But to those who are bitterly disappointed, as I am, over what I presume will happen here today in stripping away their reproductive rights, it is not the end of the democratic process. This past Tuesday, there was a referendum in Kansas, a mighty referendum, where the supporters of reproductive rights overwhelmingly prevailed and crushed their opponents. So I say, let there be a similar referendum here in Indiana soon, very soon, at the ballot box, so that while your voices were carelessly ignored in this special session, they must and will be heard on that day by your choice at the ballot. I'm going to vote no on this concurrence motion, and I urge you all to do the same. Thank you, Madam President.
Further discussion, Senator J.D. Ford. Senator J.D. Ford is recognized to speak on the motion to concur.
Thank you, Madam President and members of the Senate. I know that A lot has been said, and I just wanted to take this opportunity to summarize how I see it from my chair and what Senate District 29 constituents are asking of me. Of course, Senate District 29 has folks who want me to vote for this bill. But I will share with you that it has been overwhelmingly all the calls, emails, people stopping me at the grocery store asking me to vote against this bill. And so that's the purpose that I rise tonight. I ask you again, what are we doing here? We find ourselves here late at night to debate whether or not Hoosier women should have basic rights. While I will gladly stay as late as I need to answer that question with an emphatic yes, we're stuck here having to debate something that really should be quite obvious in my opinion. Reproductive rights are women's rights, abortion care is health care, and every woman should have the right to make her own reproductive health care decisions. It should be between her and her health care provider. Poll after poll, survey after survey, everyone in this body knows that Hoosiers across the state support a woman's right to choose. If this is not true, release the poll results. Let us see it. I know you saw what happened in Kansas, as Senator Lannon alluded to, but I also know because of the gerrymandered districts that we have in our state, I believe you are willing to weather this storm with the thought that these women will just go away. Well, I am here to tell you that they are not and will not be going away. By passing this legislation, we are kicking a hornet's nest with the legislation, especially when we don't have to. This body, elected of, by, and for the people, I might add, has determined to put on blinders and earplugs and follow ideological views instead of the will of the people, which is why you voted down Senator Taylor's amendment to put on a non-binding resolution on the November ballot. You must be worried that Hoosiers know this. Women came down here in the numbers to pour their hearts out and to share the most vulnerable parts of their lives. I heard their stories. However, we shouldn't be shocked that we're going down this direction. For too long, we've seen women in this Hoosier state treated as second-class citizens, and I don't say that lightly. Allow me to elaborate. According to DWD's own information, women in Indiana lag behind the national average wage gap, making 72 cents for every dollar a man brings home. A few sessions back, this body passed a hollow pregnancy accommodations bill. And I know my colleague, Senator Alting, tried his very best to thread that needle, but unfortunately that bill fell short. I was in the committee hearing that testimony. Women were asking for a break. They were asking for an extra bathroom break, an extra water bottle at her station. And I remember hearing a story from the brave woman and courageous woman who shared that because she was denied those things, she had a miscarriage. And we failed her. And by passing this, we are prepared to fail many more. Indiana consistently ranks as one of the worst states for maternal mortality rates. We've heard those statistics. But what's even more damning is that it's for Black women and other people of color. In other words, it's dangerous to live here and be pregnant. That's what this special session should be about addressing. This crisis of us being third in the nation. That's what we should be doing here. And now, on top of all of this, we have to debate whether or not women should be forced to have birth in our state. Think about that. We can't even provide the adequate accommodations and safe births now. But here we are debating whether or not to force women to have them. And these forced births will flood our state agencies. DCS will see an influx. Our schools will see an influx. I hate to say it, and I know I voted for Senate Bill 2, but that dollar amount in that bill is a starting point, but it is not enough. This comes, mind you, despite overwhelming opposition. When this bill came before the Senate, we heard person after person testify as to how bad this bill would be for Hoosier women across our state. All of us have received those emails, phone calls, letters. Some had to make a decision to terminate their pregnancy because it was such a high risk that the kids could be left without the mother. Some couldn't bear to know that they were carrying a fetus that had no chance of survival outside the womb. Some are so young that the kids themselves aren't physically able to give birth. And that's really what this bill boils down to, in my opinion. It's not pro-life, it's pro-birth. Because once the kid goes through life, and life's too hard, and by that I mean by being gay or trans or whatever, you throw them away. Your votes tell me that. We offered amendment after amendment to this bill to truly support life, and they were all rejected. We offered amendments for life insurance in the womb, housing support for mothers and newborns, protections for pregnant inmates, reasonable accommodations for pregnant women, and so much more. This past session, we had a chance to extend SNAP benefits to needy mothers and children, and you said no. When this bill was heard in committee, doctor after doctor testified against it. It's an honor to represent those healthcare providers, especially after what they have done for us to get us through this pandemic and what they're currently still doing. But they spoke to the fact that this decision to terminate a pregnancy should be left to a woman and her doctor. We should get out of the exam room and not interfere with this patient-provider relationship. Forcing women into dangerous or unwanted pregnancies can have disastrous effects on our public health, a public health system that is already tapped. You know that, I know that, Governor Holcomb knows that, and that's why the Public Health Commission just released a report showing how much more work we need to do in our state. No one in this body has a medical degree, not from my knowledge. So let's leave this decision up to the professionals. When did we decide to stop listening to our doctors and our public health experts? The misinformation and the mistrust of our public health experts and people pretending to be medical doctors on Facebook, I believe, is a danger to our society. We should have learned then, but here we are, ready to go against doctors' orders once again. In committee, faith leaders from all backgrounds and religions came out in opposition to this bill. Some pointed to their concerns about the impact that this would have on women, minorities, and public health in general. Some even noted that this bill would prohibit their free exercise of religion, a fundamental right in our country's Constitution. I'm here to say that this State House is not a church. Your religion should not trump another person's religion. We are not a Christian nation. However, we are a nation full of Christians, but we also are a nation full of other religious beliefs, including Judaism, Hindu, Islam, just to name a few. Our melting pot nation is what I love so much. Different people, different ideas, different religions is the very fabric of our society. Not one religion should be favored by the government over another. Our country's Constitution also protects the establishment of religion. We cannot allow ideological beliefs of a few to determine the outcomes of everyone. Supporting a woman's right to choose does not force a decision or a situation on anyone. Rather, it provides options and choices and opportunities for a woman to make a decision that is best for her and for her beliefs. That is exactly what choice is. We cannot simply follow the First Amendment when we want to and then forget about it when it's convenient. An explicit constitutional right to privacy is up for debate. I get that. However, I would submit to you that the Constitution does provide citizens their Fourth Amendment right, which protects from unreasonable searches and seizures. Someone's Fifth Amendment right says that you have a right to remain silent and not incriminate yourself. So it doesn't specifically say anything about privacy per se, but when you add these amendments up, I think this speaks to the conversation that we are having today. Women should not be forced to do something by her government. which is exactly what this bill is trying to do. I hope you can see the argument that I'm trying to make here tonight. Taking away a woman's right to choose because it fits a narrow ideological view flies in the face of what this country and this state is all about. I want to specifically thank Addison Bell for her testimony before the House of Representatives. You might remember this story of Becky Bell years ago. And she held a picture up of her beautiful Aunt Becky and shared that we cannot have any more Aunt Beckys in Indiana. By passing this bill, that's the world that we're going back to. We know that the only way to reduce pregnancies in our state is comprehensive sexual education and contraceptives. Yet we've done nothing here to expand access to contraception because House narrowly rejected an amendment to allow pharmacies to prescribe birth control, something other states have done and have seen significant reductions in unplanned pregnancies. Let's not forget that a special interest group has thrusted this bill upon us. Remind me again why we are letting them drive this boat. Remind me again why we're letting those ultra-conservative beliefs become public policy to our state. I was pleased to see the House remove the penalties, the affidavit requirement, and the AG requirement. They also pushed back the implementation date from 9/1 to 9/15, and as the conversation that I had with my colleague earlier, I don't think that that's going to be enough time to get this bill in a good shape for our state. And on that note, during the House testimony, we heard a study where Indiana medical trainees, 80% of them, said that passing this bill would likely cause them to leave this state. What will happen in our state when we cannot find these experts? What will happen in our state when we don't have the appropriate amount of number of OBGYNs? I want you to be reminded of this conversation that we're having here tonight. So here we are, once again debating whether or not the voice of the vast majority of Hoosier women will be heard in this body. Hoosier women, I am here to tell you directly that I am listening to you. We are debating rolling back the clock for 50 years. But I want you to know that it's going to be a long road back to bodily autonomy. Long, bumpy, arduous. However, I will be on that journey with you every step of the way, whether I am in this body or not, and that is my commitment to you. Colleagues, this is the last opportunity for us. We can vote no on this bill and be done, and I encourage you to do so. Thank you.
Senator Mountain. Senator Mountain's recognized to speak on the motion to concur.
Thank you, Madam President and members of the Senate. Today's closing arguments are extremely hard for me, just like I'm sure it's hard for you all, especially for the women in this chamber and for the women and families and doctors across the state of Indiana, especially the women that have to relive a lot of traumatic experiences. Ladies and gentlemen of the Senate, today we have a chance. I know we have a few more moments while folks come up to this microphone and persuade each other to vote one way or the other. I'm just naive enough just to believe some folks may change their heart and their mind today. We have a chance to change the course of the division and the dissension that Senate Bill 1 has caused this chamber and the entire state that has endured for the past 2 weeks by voting no today. I firmly remain in opposition of Senate Bill 1, and many of my colleagues have already expressed some similar feelings I have towards this legislation. I won't spend a lot of time, so let me just jump into my remarks sincerely. But let's be clear, Senate Bill 1 is simply a government mandate that interferes with the private medical decisions of a woman. And as this great nation, Senate Bill 1, in my humble opinion, will go against the First Amendment of the Constitution of the United States. And I quote the First Amendment, it says, "Congress shall make no law respecting an establishment of religion," end quote. Recognizing the unique and intimate nature of religion, the Founding Fathers wisely put religion on a different footing from other forms of speech and observance, mandating a strict separation of religion and government to ensure religious freedom for all individuals and faiths. The founding fathers had a keen understanding of the religious persecution in European nations resulting from official state religions and religious wars. So after hearing from different faiths and even Christian denominations, this is why I offered my amendment to allow religion to be an exemption or an exception in this bill. Because various religious Hoosier leaders personally came to this microphone, to this chamber, and suggested this bill goes against their beliefs. So in short, I believe Senate Bill 1 replaces religious freedom with government control. Now to the doctors out there, I just want to send a quick thought and praying that you are able to navigate this as we find our way through. If Senate Bill 1 were to pass, we're putting Hoosier doctors across the state between a rock and a hard place. Just like we were elected as officials to take an oath, and everyone in here stood before this body and stood before the state and took an oath, doctors also took an oath, that Hippocratic oath. And that Hippocratic oath, it says, first, do no harm. First, do no harm. And I seen a report of a doctor that made comment that says, if I have to make a decision of a life and death of a person that is before me, what do I do? Do I call an attorney first before I make a decision on how to act on this person? These are the decisions that doctors and all healthcare professionals that deal with women in pregnancy will have to be faced with. Before I close, I just want to personally thank the women in our caucus, Senator Breaux and Senator Yoder, just for standing up and sharing with us personal stories and testimonies that very touched our heart and representing not just women, but black women as well, and being their voice and speaking up for those young ladies that may not have anyone that can speak up for them. I just want to thank you for that. But as I prepare to close, I respectfully suggest that this process was flawed from the beginning. This process, I repeat, was flawed from the very beginning. And let's take a look at it. This bill was not even heard in the Health Committee, a very serious healthcare matter, and it wasn't put before the committee that respectfully deals with all healthcare issues in the state of Indiana. Several individuals did not get a chance to testify. Hundreds and hundreds of people came to the State House and wanted to voice their opposition or in favor of, but they did not get a chance to testify. And the next issue that I have problems with is that we weren't even able to offer all of our amendments in committee to make a very valid and solid argument on why we should make these amendments in this bill. All of these things, in my opinion, is not a good reflection on our democracy. So, lastly, one of the signs that proves that this process was flawed, how do you expect to take 50 years of president-in-law and Roe v. Wade and hammer out and negotiate something with the House in 10 days? How do we do that? Something such of importance to life and death of people, and we're going to hammer out a deal in 10 days when we have 50 years of a law that set precedent when it comes down to Roe v. Wade. In my opinion, this was never about pro-life, but pro-power. This was projecting, and I quote from the author, the will of the majority. The will of the majority over the minds, the bodies of millions of women and girls. So today, again, I stand in opposition to this bill. I respectfully ask for my colleagues that voted on this in favor of this, that when they sent it over to the House, to change their minds and allow Hoosier women to feel respected and allow us to move forward this process and set an example in the nation that we will listen to the women. And I think Senator Landis said it best in terms of how Kansas held this in terms of a referendum. If this passes, the only referendum that's left is in November. And just like we've heard in those hallways, remember November. So with that, I ask my colleagues to defeat this bill. Thank you.
Senator Niskotsky. Senator Niskotsky is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. Article 1, Section 3 of the Bill of Rights reads, "No law shall in any case whatever control the free exercise and enjoyment of religious opinions or interfere with the rights of conscience." If all people are created equal, as our Constitution clearly states, that says to me that all men, women, and children shall not be controlled by any law that interferes with their freedom of conscience. Freedom of conscience is defined as a right to be free to think and to believe as you will without the imposition of official coercive power over those beliefs. Free to think and believe as you will. Fellow members of the Senate, our right to worship Almighty God according to the dictates of our own consciences, as Section 2 of Article 1 states, this speaks to the unalienable right that God gives us each and every one of us, the gift of free will. Nowhere does it imply that this gift of free will shall be subject to government intrusion into a woman's right to choose based upon her belief in her God and her own right to exercise her own free will. I stated it last time and I stood at this podium, and I'll state it again tonight. As an individual, I am pro-life. I don't want women to have abortions. In my role as a state senator, however, casting my vote this evening on Senate Bill 1, it is my responsibility to the residents of Senate District 10 and to Hoosiers in the state of Indiana to not obstruct the rights of women to exercise their rights of conscience and their rights to their own free will. I will not impose my will upon their free will in an attempt to dictate my personal beliefs upon their lives. Hoosier women are going to have their right of free will taken from them by the decision about to be cast within this chamber this evening on Senate Bill 1. As an individual with free will, I cannot let my individual beliefs intrude upon the equality and free will of women in our state through a governmental act of intrusion. I respect the dignity and freedom of every individual person, man, woman, or child. No will be my final vote on Senate Bill 1 tonight, and I hope yours is also. Thank you.
Further discussion? Senator Griffin? Senator Griffin is recognized to speak on the motion to concur.
Madam President, thank you. Madam President, members of the Senate. Reinhold Niebuhr, I've mentioned to you before, he's one of my favorite theologians and philosophical thinkers. And the problem before us today, in some respects, vexes the best philosophers, theologians, scientists, medicine people, and we as lawmakers as well. But I'd like to try to use one of his definitions from one of his works that I've thought about a lot as somebody who has been a public servant and has thought about public policy a great deal, but I must say not the way in which I've had to think about it these past 10 days and how deeply. Niebuhr, in defending democracy, once said that it was a method democracy. It was a method of finding proximate solutions to insoluble problems. Think about that. A method of finding proximate solutions to insoluble problems. Boy, has that spoken to me this week. And while I encourage people to see my remarks of July 30th that are still inform my position on this matter, I also associate myself with my colleagues who've preceded me here on this matter. I want to offer that as my metric to discuss a closing way for us to speak to this issue as lawmakers tasked with making this judgment for the people of Indiana. I'm not sure we ought to. I've shared with you already that I'm a person of faith, and I recognize how faith is informing really the predicate to even having a law to bar the cessation of pregnancies in the way in which this concurrence to SB 1 does. I recognize it because I am of that faith, and it informs my beliefs about what we ought to do. But like Senator Nagoski, I don't believe those ought to be put into law and compulsory upon people in a democracy like ours, where religion and its plurality has to be honored, even the people whose faith may not be evolved at all and with no religion at all. What informs this in my judgment is a belief of when life begins. And because of that belief, it informs then the construct of the law that follows. And yet I believe that probably, even in this room, many of us co-religionists, some not, would have difficulty or could at least identify where the difficulty lay. I don't think a person here, woman or man, doesn't believe that there's value in the life, the inchoate life that's in the woman, as well as the life of the woman herself. I don't believe that anyone believes that that tension between the two should be taken lightly. But how we regard that human life, whether we think of it as inchoate life developing into a fetus whose ability to survive in the early stages of development is so symbiotically related to the health of the mother herself and the care that the mother takes, knowing that's going on, or whether we want that life to be just seen as separate, tangible, individual. That's where I believe the proximate solution vexes us. I've prayed about this for discernment. I've prayed that perhaps we would find a place where we could come to a place where we could talk about this more later, but it's before us tonight. So that's my first analysis about that issue, that we should not be making laws that are so deeply and intrinsically defined by a faith-based view to inform its rationale that it feels like an establishment of religion. I also think that we should be careful about abridging any religion, Madam President and my colleagues, because just confining myself to the religions that share a legacy of Abraham. We know that in Islam, which shares Abraham as a legatee, that there's a belief that life begins at conception, but the soul doesn't really get ensoulment until 120 days post-fertilization. And so within that 4-month period, there's the opportunity for all kinds of intervention that might be necessary because of complications in the pregnancy and the mother's needs. In Judaism, there is even a difficult time to even speak about when life begins, because so much of their view of this is really set postpartum, at birth. And therefore, in some stages and with some pregnancies, their faith not only allows for intervention for medical necessity, it requires it. And then there's Christianity. I had a religious studies professor that praised the First Amendment, Madam President, one time because he said it was the greatest act of deregulation of religion ever. We deregulated religion in America. And that's why when we speak of Christianity, it is a large variegation of belief systems, many of which have a common confession, but is very different. And even in Christianity, not all Christians agree, even if they agree with when life begins, about how appropriate it is that that life should subordinate the life of the woman carrying it. So I'm concerned about the establishment of religion that I believe is implicit in this law, as has been said by my colleagues. I also think that one of the objectives I heard said by advocates of this bill, Madam President, was the balancing of the interests of life of the mother and the interests of life of the child. This often is called, in the science of this, viability, a word that we've used a little bit tonight, I've heard, but we really have never used either in the existing law that governs this matter now or the law that would presume to succeed it if adopted this evening. We hide it in words like 10 days or 20 days and so on. And I recognize that those are attempts at deciding on viability, but as also was mentioned this evening, viability can be different for every child dependent on their individual situation. And while most medical people say that viability can be anywhere between 22 weeks and 24 weeks, even if viability occurs at 20 weeks, it often is still the ability of that child to live outside of the needs or outside of the support of the mother is still challenged and vexed by health conditions that complicate things. Even outside of these exceptions, which are a way of perceiving viability, this still operates as a ban that hadn't been there before. And so even if there's language that was modified from the first iterations of this bill to try to make it look a little bit like the exceptions that are listed in the current law that governs this, medical professionals are still going to be somewhat flummoxed and perhaps challenged by moving forward because they've never had to operate with those words that look like the words in our current law in the context of, except for the exceptions of life of the mother, rape and incest, a procedure that is now banned outright if this law is adopted. So it complicates the practice of medicine. So, by way of summary, using the metric of Reinhold Niebuhr's ideas, who said that democracy was a method of finding proximate solutions to insoluble problems, it seems to me that the concurrence in SB 1 is not a proximate solution for an insoluble problem in that it doesn't properly address when life begins, because for theologians and scientists it can vary. Among us, even people of faith, we can deeply believe when we think that life begins. As I shared with you before, as a person of faith, my statement about when my daughter was born, I believe God knew her before I met her mother. But I know that that's not the way of knowing that is empirical and scientific based. It is faith based. And I feel like it mars this law by informing its rationale for being passed. I don't think it is a proximate solution that to an insoluble problem when we legislate from one faith and don't take into account the diversity of faith in our country, even if we narrow it to those faiths that share the legacy of Abraham. And it's not a proximate solution to an insoluble problem that reckons well the limits that government ought to observe. Here I am, arguing for limited government. In determining to decide for a woman an issue that is so deeply personal, consequential, and imbued with their own view of faith that is both personal, complicated, and best left to that woman to follow both the dictates of her conscience, her faith, and the counsel of her health care provider. So, if Niebuhr is right, that we as lawmakers in the context of American democracy are supposed to be using it as a method to find a proximate solution to an insoluble problem, it is my belief, my colleagues, that this bill, this concurrence, doesn't really meet that metric, and I would ask that you defeat this concurrence, that we may come together later to try again and do better. Madam President, I thank you.
Senator Bohacek. For what purpose do you rise?
To speak on the bill.
Senator Bohacek's
thank you, Madam.
recognized to speak on the concurrence.
Sorry, thanks. Thank you, Madam President, members of the Senate. I've got a whole piece of paper full of statistics and stuff, but you know, every other year in the budget year, we come here, and I do it, and I pass out pins to celebrate Down Syndrome Awareness Day, 3/21. And we bring people in, and they come in, and you know, we have resolution, and that's great. But today, this bill offers no protection for them. So most of these folks are on guardianships, and unfortunately, they are assaulted at a 10 times rate of everybody else. The underreporting on this is almost 85%. So I'm not a lawyer, but what happens to somebody that's on a guardianship that's pregnant? Don't know. What happens to the baby? What happens to the decisions? Nobody knows. And I'm pro-life. I am. I mean, I stood with, I don't want to say his name, but he's 4 rows behind, in front of me. And we defended some abortion legislation on third trimesters for genetic reasons. And thankfully, that's now in state law, because it needed to be. But this concurrence misses this opportunity to be able to address this. My daughter's 21 years old. Excuse me. If she lost her favorite stuffed animal, she would be inconsolable. Imagine making her carry a child to term. Thanks.
Further discussion. Senator Pohl. Senator Pohl is recognized to speak on the concurrence.
Thank you, Madam President. Previously, I'd mentioned that the governor had called us here to help families, not strip away rights in a rushed and dangerous way. But it's exactly what we're doing. Senator Taylor, Senator Griffin, and Senator Yoder accurately pointed out the shortcomings of Senate Bill 2, and we heard excuses about how that's all we can do right now. We'll need time to figure out the impact of the well-intended proposals that didn't make the cut, but maybe better luck next time. That's apparently not the case for Senate Bill 1. This isn't a small increase or tax or regulation. This is a seismic shift in some of the most private and deeply held personal and civil rights we've held for a lifetime. Besides being a dangerous precedent of government overreach and intrusion into the most private parts of our personal lives, it sends a message. Indiana doesn't trust women and young girls. Indiana doesn't listen to experts sounding the alarm on serious medical and mental health issues. Indiana is too focused on stripping away rights to understand what happens to poor women who become pregnant, whether purposefully or forcefully. I mean, let's be honest. Those that are well off are going to have options. They'll be able to leave the state, but poor women, without the means to leave the state, without the means to, or without anybody to support them, they're stuck. Indiana does not care about what your plans are for yourself, your kids, or your family. And lastly, Indiana ignores the majority of the constituents. Kansas should absolutely be on everybody's mind. Numbers showing a 20-point blowout in one of the reddest states in middle America. There's no more clear indicator that this is not about political identity. This is about civil rights, personal autonomy, and freedom of overreach into one of the most personal aspects of our lives, particularly in the lives of women. I think Senator Boots and Senator Becker, for their clear message, was very on point on that. Many of those that identify as pro-life understand that that can mean pro-life in their personal capacity. It's not a political identifier. This is something that cannot be gerrymandered. If it could be gerrymandered, Kansas would be debating the same ban right now. For many, it's a personal belief. Some could just not bring themselves to terminate their pregnancy and would likely raise their children with the same views. Those voting against this bill are not telling you that those views are wrong, that what your belief on the gift of life or the sanctity of life is wrong. That is vastly different than imposing those views on others and telling others what they can do with their body. That message is apparently falling on deaf ears, unfortunately, intentionally deaf ears. Many on both sides of the aisle offered a state referendum on what the constituents want. It was rejected, but I think we all know what the majority wants, and it's not forced government intrusion into doctors' offices. I know you can hear those brave women out in the hallway right now. I mean, it's impossible to not listen to them. To force birth onto somebody who's not ready, willing, or able will undoubtedly be a traumatic experience for many, but particularly those that are the most vulnerable. Those without the ability to take care of themselves, let alone another human being. We're forcing them to give birth. And when they simply can't care for the child, the response is, oh, just give up the child, give up that part of you, into the adoption and foster care system that is already wholly underfunded and unprepared for your child. That's not a knock on those that diligently work in the adoption and foster care system, who are currently making poverty wages, roughly $11 an hour, to care for foster children. That's a knock on us sitting in this room, sitting on a surplus and pushing through a bill that will further overload these systems, for trying to cram a seismic change that really should be substantively and thoroughly studied before being pushed through two bills in a truncated session. So let's take a bird's eye view of that option. Over the past couple of years, we had an all-time high demand in foster care. We drastically increased from 11,000 kids in foster care in 2006 to 20,000 in 2016, an increase of 74%. Now we're roughly at 27,000 kids currently in the foster care system. As of right now, Indiana has 10 foster placements per 1,000 children. That's the real world. This is the average of everyone's district in this room. These are some of the things that some districts will see and others won't, but it doesn't change the fact that that's what our state is, where the current state of our state is at. We have an adoption system that obviously can't keep up with the children it currently has. And without substantive assistance with SB 1, we're essentially saying here, potentially thousands of additional children. In committee, we heard testimony of Shannon Shoemaker of the Villages of Indiana, who presented information demonstrating that just 300 more children in the foster care system would be about $14 million more just to pay the foster parents. That's just 300. We're on a trajectory over time that continues to climb, and forcing birth on those would otherwise not give birth would only keep those rates on the rise. Now, I watched testimony from the witnesses who knew strong women and raised their children after having teenage pregnancies. Some after traumatic experiences. These were amazing stories of strength and perseverance. But it goes without saying, that's not data. That's not data for us to base a statewide mandate on forced birth. In fact, many folks in the state are already that have a medical emergency, one medical emergency away from being bankrupt. One simple mistake or an accident and they lose everything. To assume that such amazing stories of strength by a few are an acceptable support for a drastic and draconian policy change of forced birth is unacceptable and objectively dangerous. The average yearly cost for a center-based infant care is a little over $12,500 a year. Now, this isn't really a new development for most of us, but for those that are unaware, we're currently in a child care affordability crisis. Infant care costs more than both college and housing. Even the median family that earns $4,777 per month would have to spend 22% of their gross household income on a single child for infant care. For those making minimum wage, 85% would go to infant care for one child. Now, if we increase the amount of infant child care vouchers to 4,000, that'd be about $72 million. We're simply writing checks that we have no plan to cash. Now, the House made some changes, but the one that demonstrates arbitrary governance, I think the most, is the changes to the exceptions. 10 weeks to tell if you're pregnant if you've been raped. A little girl whose body's already changing so much, who may be terrified to tell somebody what happened to her, who may not even understand what it means to be pregnant in the first place. She now gets less time to figure out her body trauma from when this bill left this chamber. She's got to figure out her trauma, her support system, and ultimately the trajectory of her life with 2 fewer weeks. And the Senate says nothing. We don't say no to that, we just concur. 12 weeks was wholly arbitrary, but no demonstrable rhyme or reason, no data-driven support, no reliance on scientific research or studies. 10 weeks is unreal and flat-out cruel. Testimony from the House demonstrated specific circumstances in which a child who gave birth didn't want her newborn baby. She just wanted the doll that she just received as a present. That's who the state is going to force to give birth. Business leaders, education institutions, young professionals, medical professionals, women who fought for their rights, their granddaughters who never thought they would lose those rights. The whole damn world, they have eyes on this chamber right now. They're thinking, are they going to send Indiana back into the dark ages where women are treated as second-class citizens, that women can't control their bodies? Or as one proponent of an all-out abortion ban put it, that they should feel shame for climbing the corporate ladder rather than raising a family they weren't ready for. What's the headline going to be? Time and time again in this short session, it was made abundantly clear that we're wholly unprepared for this, in this state and this legislature, for a seismic change of this matter. Dire, certain, and unimaginable circumstances and consequences are something to discuss later, but not before passing this terrible bill. This is just negligent and reckless in a way that this state hasn't seen before. I said it before, and I think it rings true. The way that this looks is control without care for the consequences, the personal beliefs of some over the personal autonomy of others. If we don't stop this now, we know the special interest groups that pushed for this legislation in the first place will undoubtedly return next session, continuing to push this legislature to up the penalties, to get rid of the expectations, to get rid of the contraception, to ignore science, to ignore the doctors, to punish the doctors, and anyone else not adhering to their beliefs. My colleagues and I will fight for those individuals to practice those beliefs, to hold those beliefs, to publicly display those beliefs. But I could never vote to allow the personal beliefs to take away the privacy, the rights, the health care, and the autonomy of others. I'm voting no, and I urge all of my colleagues to do the same.
Senator Young.
Madam President, if I could add.
Senator Young to question Senator Glick. Will you yield? Senator Young.
Thank you, Madam President, members of the Senate. I just have one question. It's on page 12. Here, do you want? I'll give it to you. Oh, okay. All right. All right. Page 12, lines 1 through 4. The reason I'm asking the question, because I really don't know how this applies. The language simply says, this article does not apply to in vitro fertilization. And this is regarding the abortion chapter of 1634(1). Does that language mean that none of the laws within the abortion laws apply to anybody that's had a baby that's conceived through the in vitro fertilization procedure?
It's in regard to the conception. Once the child is conceived and it's in utero, I think the law would apply. It doesn't apply to the actual fertilization process, as I understand it. Okay. So it doesn't go into the fertilized embryos, that sort of thing.
Okay. And I'll ask the second question, because I don't want to say anything that's incorrect. This is too important, and I want to make sure I got this right. Where does it restrict it only to the procedure itself and not to the rest of the abortion laws within 1634(1)?
This article?
Yeah, because it says it does not apply. And that's why I'm trying to figure out, if it doesn't apply to the abortion stand, there's nothing in the abortion stand that they could have. I just want to make sure. If you don't know the answer truly, I don't have a problem with that.
What's your point?
My point is, well, I'll do that in my speech. I just wanted to know what you knew on it. Permission to speak.
Senator Young's recognized to speak on the concurrence.
Thank you, Madam President. Members of the Senate. I know this is tough and sick. As you can see, my new trim self. of losing all this weight and have to buy a new belt and stuff for my clothes because it's driven me crazy. It's taken a toll on me. Not as much as women would have to face in the situation they're going to be in, but it's taken a toll on all of us because we have strong, passionate feelings about this issue. And it affects us because we care about our constituents and women who are going through this situation. And that's what we're doing today and why it affects all of us. But I'll tell you what, this bill went over here to the Criminal Law Committee. Had it come to our committee, I don't know what we would have done, but I can tell you this, we'd have probably studied it a little bit better and looked at the issues, and I thank all the members on our committee for the job that they do. They're very thoughtful. They look at all the different scenarios that could apply and say, well, we need to do this, we need to do that. And I'll hold the bill for 1 or 2 weeks and not rush it through. But let me go through some of the problems with this bill. And for the life of me, we got 9 days left and we're being told we need to end this now. These are things that we can fix because I know that they're wrong and they're simple fixes. All we have to do tonight is just not concur. The bill's not dead. The language is not dead. It goes to a conference committee where we can hammer it out. We do this all the time on conference committees. So this is not a new issue with us. But this is the only time that we'll have, probably, to fix these issues. And why do we want to lose an opportunity that this may be the only time? I'll tell you what, I've heard stories here in my 35 years, and here's some of the stories I've heard. Just help me pass it over to the House over there so we can fix it. I hear that all the time. And what that language really means is simply this, for the most part. We're going to do what we need to have done and not what you want to have done. And we'll get it fixed that benefits us. Then the other thing I've heard is, go ahead and pass the bill, please. Please pass the bill. We'll come back in January and fix it. That's the death knell. I've never seen it done. I've never seen it done. And the reason is, we have the opportunity to fix it while we're here. That's our job. We're here right now. We got 9 days to go. So let me go through, and anybody can tell me what is wrong with anything that I've mentioned here and why we couldn't fix it now. There is no verification on the 10-week period. The law is pretty good. The doctor who says that's doing the abortion has to certify it in a letter that it's 10 weeks. But what if it's 11? Who knows? Who knows if it's 11 or 10? Who knows if it's 14 or 10? Who knows if it's 19 or 10? The doctor is the only one who has that information. How do we know? No one has to verify it. They don't have another doctor who will come in and verify that the gestational age of that child, that unborn child, is only 10 weeks. And they could commit a crime, but no one will ever know. It's in the file, but who looks at these files? I don't know. I don't know. I've never heard of it ever happening on an abortion doctor. And we got a great example of the one up in Allen County of all the babies that they killed, and no one knew. No one knew. Over 1,000, and no one knew. Yet we're supposed to know and trust somebody. They're going to verify the gestational age of 10 weeks. They won't. There's no verification that the woman was raped. We could require an examination. Now, a doctor, I'll tell you, they won't be able to tell you if the woman was raped, but they could verify the information based on the examination, and it appears to be, and that would be good enough for me. But there's no verification on that. There's no verification that the child is a product of incest. None whatsoever. And for a child under 16 for the crime of rape or incest, they have a 3-day reporting period. But if it turns out afterwards, the abortion, the 3 days notice is done because the baby is dead. The baby is dead. There's no requirement to maintain the DNA evidence. Now think about this. What if the woman later, and I know, and I'm not a woman, but I know this, they're under a lot of pressure. And they make decisions and not clearly thinking through it, because when I'm under pressure, I make mistakes all the time. And I try not to do that while I'm under pressure. But they may make mistakes. But you know what? If they don't keep the DNA for the rape, what happens if a year or two the lady comes back and has the courage, has got over it, has got a control of her emotions, and said, this guy over here is the one that raped me? Well, where's the requirement that we keep the DNA evidence? And Senator Crider's done a lot of work in regard to the DNA evidence and on these rape kits, but we don't have any requirement that they keep this evidence so we can use it against this rapist. And who in this body wants that person to be free on our streets? Take the evidence, keep it so we can use it later if the woman changes her mind and prepared to testify. A minor has till the age of 31 to make a claim against somebody who have sexually assaulted her. Little kids may not be ready to go. We know they're not prepared. Senator Yoder says all the time about their minds not being developed. We've heard all the time here about how people are upset and it hurts them and it bothers them. Well, imagine that same pressure on a little girl. But 31 years later, she has enough courage to say, it was my uncle who raped me or committed incest. We no longer have any evidence in which to put that person behind bars. It's now that little girl's word, as she's older, against somebody else that said, I never did it. But if we had the DNA evidence, it wouldn't be a problem. And what we're saying, we can't fix it while we're here? Seriously? There's no requirement that the parent is even notified if it's a rape or incest. Now, I got some other evidence I'll show you in a little bit, but just because somebody says it is rape or incest, and I got the idea that most women probably aren't going to lie, but some do, and I've got the evidence here that that does happen. But the parents don't even have to be notified. And what if she gets an abortion later and says, I feel so bad. My uncle never raped me. My father never raped me. My brother never raped me. A little baby's dead, and there wasn't even a crime that was committed. But we don't have to check it out. Now, if the little girl's life is in danger, I'd say do whatever you have to do to protect her life. But if it's not, maybe we ought to try to find out what's going on here first and see what has happened. You know, we get rid of the abortion clinics, and that's fine. I don't have any problem with that. I want to see them gone too. But all they were doing was doing the oral medication that any other doctor can give them. But we force the doctor to go to the hospital. They can't even do it in their office. So a doctor has to close down his office, to go to a hospital, to give the woman the oral medication that he could have simply done in his office. I don't know why we're doing that. That makes no sense to me. I have to wait long enough on my doctor. I don't want him to get up and have to go to a hospital that he has privileges at to give the woman the medicine that he could give to right there in his office. And there's no requirement like the COVID shot, I have to wait around 15 minutes. There's no requirement that the woman, after she takes the medication, has to wait there. They can leave. What's the purpose of doing this? I don't know, but we could fix that. You know, what if the requirement we have, which is a great one, that at viability, we have to have a second doctor there to do everything they can within their power to protect that baby's life. That's at 20 weeks. What if this same doctor says it's only 19 weeks? And yet the baby's really at 21. Where's the second doctor come in? Who's there to protect that little baby's life? You know what? Nobody is checking that record. Why don't we have another doctor look at the gestational age of that baby and confirm it before it's done? And if it's over 20 weeks, they have to have the second doctor. If it's less than the second, they don't need it. But there's nobody that's checking. And you know what? The end result is that baby's going to be dead. It could have survived on its own. But there's no requirement because one person's doing it, and we don't know if it's right or wrong. What if the doctor actually made a mistake? They are human beings, after all. I make mistakes. You guys point them out every time I do it. You know, on this issue about in vitro fertilization, You know, I'll tell you what, Senator Cook is probably a better attorney than I am. Senator Freeman's probably a better attorney than I am. And let me just say this, even Liz Brown is probably a better attorney than I am. I'm probably the worst attorney in this building. And Senator Paul, you're better than I am too. But this language on page 12, this article does not apply to in vitro fertilization. None of the abortion laws, that's where they are in 1634(1), none of the laws apply to that. You could go 8 months, 6 days, 23 hours and have an abortion because nothing in Title 16, 34(1) applies to the procedure of in vitro fertilization. We can fix that too. Why are we going to allow this to happen? Because you have some procedure, none of the laws apply to you, but they apply to somebody else? Well, how is that even fair? Why is that even right? Why are we even doing it when we have 9 days in which to change it and make it right? And that is our job. You know, a doctor for an unlawful abortion, and I don't know why we're doing this at all, a doctor can't be charged with feticide or murder of the mother or voluntary manslaughter. Why is it that we would want a doctor who's going to commit a crime and let him go scot-free because, oh, doctors won't come here? Doctors will leave here? Well, wait a minute. Why do I want a doctor that's going to violate the law? Why do I want a doctor who's going to violate the law? And why does he get a pass on breaking the law? And we have Senator Freeman used to be a road deputy, and Senator Kreider is a law enforcement officer. Can you imagine that they're out there on their duty, they put their lives on the line, they find somebody that committed a crime and arrest them, and the law says, oh, wait a minute, because they're a doctor, they don't get charged with those things. What kind of law is that we would do that? That we'd let somebody break our laws just because they're a doctor? That makes no sense to me. But you know what I know? We have time to correct that. We have 9 days to fix that. Forced abortion. That's very serious. This usually comes from trafficking people. And I know Senator Kreider's worked a lot on this one too. He's done a great job. And I let him carry a lot of bills in my committee on these issues because they're important and it protects people's lives. But here's what the doctor gets. This is what the doctor gets if he violates 1634 1-1.1. If he violates that section of the law dealing with coerced abortion, guess what his penalty is? Or her penalty? Anybody know? It's a Class A infraction, anywhere from $1 to $10,000. It's not even a crime. It's not a criminal act. And we have a doctor who's going to violate it, and all they get is an infraction. That makes no sense to me. Here are some of the other laws that doctors will not be charged with. And I don't know, anybody in this room would think this is right. They can't be charged with murder if they commit a crime on the abortions, voluntary manslaughter, involuntary manslaughter, feticide, and serious bodily injury from a battery. Why do we think that's okay for them to break the law and do that? I'll tell you what, if I hit somebody, my prosecutor right here in Marion County would have me charged, indicted, and in trial. I can tell you that right now. I wouldn't get by with it. Why do we let a doctor get by with it? That makes no sense. Now, I know this issue is tough. It's tough for all of us, no matter what side we're on. But this idea that we can take away the doctor's license will solve all our problems. Well, let me tell you, I do a lot of research. I read a lot of things. And here's the research on Indiana doctors. It was conducted from 1975 to 2015 by two individuals with the name of Jing Liu, not Jean Liu, but Jing Liu, and David Hyman. It was conducted by what was it here? I think it's, well, for whatever, it came from a university out in the East Coast. And it was published in September the 13th of 2021, so it was recent. They looked at everything from 1975 to 2015 on all the disciplinary actions against the medical doctor in the state of Indiana. Of all the violations that doctors have had and was brought before the medical licensing board, guess how many doctors was even disciplined? And I'm not talking about was their license revoked. How many were even disciplined? Anybody know? 1.2%. And you think because we have a licensing requirement in here, they're going to lose their license? Why did we have, Senator Sandlin had the bill on this on the fertility doctor. Why did he get by so long? Now, I know people turned him in, but why did he go? Are you telling me a doctor, all these doctors, of all the ones that ever had charges brought against them, only 1.2% were ever disciplined? That makes no sense to me whatsoever. You know, Senator Lannon, I started to say something the other day, and we're friends, but when you said I implied that I didn't have the right to vote because I'm not a woman. Well, in my district, over half my district is made up of women. I think they're pretty smart because they voted for me. And of those women that was in my district, you know, a plurality of the women in my district were pro-life. And the thing I thought about is this. I've never hidden my position from anybody, ever. And they ask me this question, I'm a stand-up person. I'll tell you where I am. I'll never back down. I'll never apologize for my beliefs and my principles. But I know this. My district knows what my principles are. And they voted for me based on those principles and knowing what those are. And they asked me to come here and speak for them. And that's what I'm doing. I have every right to speak for the women of my district. Just because I'm male doesn't make any difference. They elected me to speak for them. And then I'm proud to be here speaking for those women who are pro-life in my district, which is over a plurality. You know, the other thing that we heard, and I don't have anything against Senator Paul on this, but I am offended that people would think that because of our stance, that we're allowing a rapist to pick the mother of their child. We're not doing that at all. But if we can't find out who the rapist is to put him in jail, we're letting every woman down, because this is the problem. Rapists don't quit. And we know about 98% of these people who do these type of crimes will never be rehabilitated. And they'll be right back out in the street unless we can find a way to stop them. Your mother, your sister, your wife, your cousins can all be raped by the same perpetrator. Unless we have the evidence or have somebody with courage to come forward, they will remain on the street harming our citizens. Our job is to protect our citizens. We have every right to do it, and we should do that. But we don't have any mechanism in this bill to do that. The only mechanism we had that we put in this bill to protect the public was taken out by the House, the non-compliant prosecutor. I know you guys don't like it. I understand. I got that. But if we don't have somebody who's going to prosecute these crimes and find out who they are, we're hurting a lot of people. We're hurting a whole lot of people. But we don't have to. And you know why? We have 9 days. This doesn't go away. It doesn't kill it. It's just another conference committee report. But is that what we want to be known for? The final thing I'll just say, this bill, I'll tell you what, I didn't like the Senate bill, but the Senate bill was much better than this piece of paper. I don't know why anybody would be in favor of this. It's horrible. It's horrible. It's filled with holes. And now, listen, I don't want you to take my word for it. Senator Taylor never does. I always have to have him go talk to Andy Hedges. And then he believes it. I tell him the very same thing, he doesn't believe me. He hears the very same words I say, and he believes Andy Hedges. I'm just telling you, I don't care who you check with. Anybody wants to check this paper and what I said? I've already had it checked by a renowned national authority on abortion laws. I had Andy Hedges also check all this and verify it. Everything I've said here tonight has been verified by people other than myself. People other than myself. And the final thing before I just make a concluding statement. I was offended the other day when the Jewish Community Relations Council said that I was opposed to their religious beliefs and that I should immediately issue an apology. I have no idea what they're talking about. I have no idea who's running that group. But I can tell you this, I went back and reviewed the tape. I never even mentioned the Jewish religion in any of my remarks. Now, they were mentioned by a couple of members over here, but it never came from me. And you all know what I said. I specifically did not bring up religion because I didn't want that to be a part of this debate. They are wrong, and they ought to stand up if they have any character at all and make a public apology to me, because I never said anything about their religious views. Now, what I did say was this. We're not going to put something in the law based on our religion that says if you commit adultery or a homosexual, that you die for it. That is grotesque. I would never be in favor of that. They cut off people's hands for theft. We're not going to put that in our law. They do all kinds of things that are barbaric. And yes, they should not be a part of our law. But I never talked about the abortion issue, about the religions, the Jewish people and their religious beliefs. I would never do it. They have every right to what they believe in on that regard. And they disagree with us, and I disagree with them. But that's part of the debate. So I'll just close with this. My job is this, to protect every beating heart, whether it's born or unborn. That's my job. That's your job as well. That's why we're here. We make decisions. And I just can't let these babies die without fighting. You know, when I was a kid, I never gave up. I was athletic. I was very aggressive. I never quit. And the only time I did quit was when time ran out. That's the only time I ever quit. I know this, time is not out. Time is not out for us to make the corrections in the bill and make it better, to help all our citizens at least be fair in the way we apply this law, to ensure that when little girls are raped or have incest, that we have the evidence so we can convict the person later on. That's all I'm after, is to make sure we have the ability to safeguard our citizens. All it takes, and I don't know if this is Thomas Jefferson or President Jackson, but one of them, because they're applied to both of them. One person with courage equals a majority. One person with courage equals a majority. I hope we have somebody with courage today that will do the right thing, that'll give us the opportunity to fix this in conference committee and make it a great bill that we can all live with, even though we may not agree with every part of it. But this idea that we can save lives from this, there is no guarantee we save one life. There's no indication in any study, and I've looked for them, that we will save one. If they need an abortion or want an abortion, they're going to go get it. The only thing we've done is we made sure it didn't happen in this state. That's all we've done. The same amount of babies will probably die. They just won't be here. And think about Kentucky. And think about Ohio, where they have stricter laws than we do. Our actually may go up because they'll come to Indiana to get those abortions. They'll come use this law on rape and incest to get the abortion. And so our numbers could go up. It's incredible to me that that's the way we look at things. It's okay if they die in another state but not here. I don't want them to die in any state. I don't want to be a state that says, we're going to take a little baby's life away because they were born in Indiana. If some other state's going to do it, let them do it. My conscience will be clear, but I don't want it to be done in my state. And so all I ask for anybody, I've never put pressure on anybody. I've tried to give everybody information to make a knowledgeable decision. It's just vote your conscience. Do what you think is right. But I need somebody in this room, that one person, who will stand up and be one person with courage to make that majority. And with you, I hope we do the right thing. Thank you.
Further discussion? Senator Bohacek. Senator Bohacek to question Senator Glick. Do you yield? Senator Bohacek.
Thank you, Madam President. Members of the Senate, sorry when I left last time I didn't excuse myself. Senator Glick, is there any provisions in this bill for moms that are under guardianship?
Yeah, there's a provision in here to the courts. You can go to the courts for assistance, as you can anytime someone lacks capacity.
But there's nothing there to extend that 10-week window, right?
No, it's up to the court.
It's up to the court. So they would
Yeah.
have to petition the court in order to ask for the 10-week window to be extended.
You would have to petition the court to have any kind of assistance in that regard.
How long does that take to happen usually?
Usually those are moved, if there are emergent circumstances, they would be advanced on the docket.
Can somebody that's under guardianship sign a fee agreement with a lawyer?
Do what?
Can somebody that's under guardianship, they would require their guardian to actually sign the fee agreement with the lawyer to actually move that forward, or no?
If they're under a guardianship, normally their guardian would act for them. They could do anything for them that they could do for themselves. The guardian could act.
What would happen to a child? I mean, if the child's born and the person is under guardianship, is it up to the guardian to determine what happens to the child, whether it stays with mom or goes?
It would depend on the circumstances. If it was an incest, it would have there would be obviously an investigation of those circumstances. If it was a rape, if it was, it depends on the circumstances.
So if it was a rape, would it, because my situation with this kind of situation. So if it was a rape, who would determine where the child goes? Would it be the guardian that would determine it, or who would?
I would say the guardian certainly would have something to do with it, but there are provisions in the law for people who don't have capacity. If a person rapes an individual who lacks capacity, there are provisions in the law to protect those individuals.
What if the person that had, because I think if you have an IQ sub 70, you're determined to be mentally retarded. If the person wanted to keep the child, could they, or would there be a hearing to determine if they had?
I think there'd be a hearing in most cases, or the guardianship certainly would have input on whether or not, if the individual lacks capacity and has a guardian appointed for them, they're probably going to have a difficult time to establish they have the requisite capacity to care for an infant.
Okay. All right, thanks.
Further discussion? Senator Kadura. Senator Kadura is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. Each one of my colleagues has the right to speak their mind. Each one of my colleagues was elected by their constituency to represent their beliefs and their principles. But I reject the idea that any political party or any legislator holds monopoly on moral righteousness. I reject the idea that someone can question the integrity of any legislator, of where they stand on this issue, especially when a process that negotiates a bill between the Senate and the House plays God and changes and negotiates the time frame from 8 weeks to 12 weeks back to 10 weeks. I don't think God sent revelations over the last 7 days to change the law of when is the time for a girl, a young girl who was raped, to understand her emotional and psychological distress of being raped at the age of 10 or 11 or 12 or 13 or 14 or 15. when I read the Declaration of Independence, that these truths are evident. I think some of us took some of the words literally, that all men are equal, and completely and literally took the argument that women do not exist. I recall when 17,000 Hoosiers died because of COVID, no one signed a letter to the governor saying, send us back to a special session so that we can protect Hoosiers. I recall that, matter of fact, what we did in this session, we went after the Republican governor to limit his powers because some people oppose the role of departments of public health in the state of Indiana, and then we question why Indiana ranks in the bottom 10 nationwide on public health, on infant mortality, and maternal mortality. We heard a lot of preaching about pro-life, and I respect the sanctity of life. And yes, I'm a Democrat, and I celebrate life. But don't tell me that it's a pro-life policy when for 2 weeks the minority agonized over trying to improve the health and the well-being of Hoosier women by supporting $250 million for their mental health, by supporting $250 million for public health, by supporting $250 million for infant and maternal health. When we start placing a price, a monetary price, on the health of women, that is not pro-life. Based on our laws, to all of those who I respect in this chamber, every single legislator with no exception, I respect you as my colleagues. I respect your passion. I respect your principles. But I have my right to fiercely disagree with you. So hear me out. When a gun in Indiana does not require a permit, but a woman needs a permit to be told what to do with her body. Maybe you don't see that argument. As a person who lost a loved one to gun violence, I do see that argument. A killing machine does not require a permit in Indiana, but moms who are producing kids for this society are treated like objects who need permits. It is offensive. The Bill of Rights, and this is not a lecture on history, but the Bill of Rights was added to amend the Constitution not to restrict people, not to take power away from people, but to tell government, to prevent government from the misconstruction and the abuse of power. Please, when you use words such as, it is the will of the majority for this bill to pass, let me push back for a second. Please do not be under any ambiguous understanding that this is not the will of Hoosiers. I preached on this podium, from this podium, and I voted against the gerrymandered maps that gave the supermajority more influence than what the actual votes in Indiana require you to have. I opposed it from a principled position. And if I was on your side, I would oppose gerrymandering. So please don't tell me that the will of the majority requires to restrict reproductive rights for Hoosiers, Indiana, just because 26 individuals in this chamber made it happen, made the law pass to go to the House so that it can impact half of our population as a beginning. But it will impact every young child, whether boy or girl, whether grown-up man or woman. I've never seen the sense of urgency for the General Assembly to come back here to call for a special session, or for the governor to call for a special session, to deal with crises confronting Hoosiers. I spoke with so many Republicans beyond what I can count. And many of them told me that they wish to stay anonymous to protect their professional careers. Some of them worked in this chamber for over 15 years for Republican senators who reached out and said, I will be changing my voting record because my own party left me. I received emails, text messages, and calls from Mitch Daniels staffers and Mike Pence staffers who said, my party left me. This is not the Republican Party that I know. I received messages telling me this is a civil war within the Republican Party between rural Republicans and urban and suburban Republicans, and women are being held hostage in this. And these letters didn't come from Democrats. They came from Republicans. No citizen should be held hostage to political infight between any political party, whether Democrats or Republicans. I fully disagree with my colleague Mike Young. I respect him as a colleague. I'm on the extreme opposite of his arguments. His position, his policy position, is an extreme policy position. But I wholeheartedly agree with him. Why rush through a process that strips rights away from people? Why? I made the argument for those who care about public policy, for those who truly care about how government actually functions, not just passing laws, for those who worked on a local level, on a state level, who understand it's not a switch that you turn on or off. Republican legislators, senators serving in this chamber today, and Republican representatives in the House publicly and privately said, we are not ready for this law to be implemented. We are not ready. Indiana's not ready. Indiana is ill-equipped to handle existing kids. What's the point of rushing a bill? We spoke about religion in this chamber. What happened to the protection of people's civil liberties and freedoms to practice their faith? Senator Phil Boots, last time I checked, was not a Democrat. And for him to say it's a small number of legislators who subscribe to one faith, who want to impose their faith views on others, didn't come from a Democrat. It came from a Republican. I served on committees. My dear respected friend, Senator Perfect, many committees, especially the labor and pensions, when we always heard good arguments, let government stay away from people or create barriers for people. Government is at its best when it's small and does not interfere with the people's lives. So what happened to that? Where's the contradiction? Can't we see the contradiction in that? My message today in closing, first is to you, my colleagues. It is easy in the heat of the moment to place political priority over policy priorities. And I also heard that from my Republican colleagues. That the political urgency for a party that campaigned for 50 years on pro-life, we just cannot leave these 2 weeks without passing something. And there's an upcoming election. These are words I heard from my Republican colleagues. And we have to demonstrate to those who voted for us for 50 years that we've been fighting for them, and we cannot go back to our districts empty-handed. That's why we have to pass something. And I guarantee you, and watch my words, come January, there will be more anti-abortion bills introduced in this session. and comes the year after, and the year after, and the year after, because of gerrymandering, you will have more legislators or candidates running for districts trying to run an extreme to criminalize physicians and maybe go all the way to level 1 felony or even the death penalty for physicians for providing reproductive care. Because they might think that you are not strict enough. They might think that you are too liberal. So when do we say that the interests of our people become above and more important than the interest of a political party? When does it become important for all of us to say that we will serve the interest of Hoosiers before the interest of a political party? To all, specifically, to all Hoosiers, but specifically to all young girls, like my 2 daughters. To all Hoosier women, those who shed tears over the last 2 weeks and the last few months in fear, those who lost hope, those who lost sleep, those who lost confidence that their government works for them, to those who gave up on their elected officials because they feel they don't represent them. Please hear me out. If this legislation passes, it will be a setback. But we will never give up. We will never give hope. We will fight with courageousness to change public policy in a civil manner, in a respectful manner, to restore these rights. I remember Dr. King, before he was assassinated, when his people were persecuted and deprived their civil liberties, he delivered one of the most hopeful speeches, where he said, "We have difficult days ahead." And believe me, we will have difficult days, even those who are going to support this bill. When you see how healthcare metrics are going to turn in Indiana, please remember that you voted for this bill. Dr. King said, "We have difficult days ahead. And I might not be there with you, but I've made it to the mountaintop, and I've looked over, and I've seen the promised land. And we as people will make it to the promised land. And Hoosier woman, I tell you, we hurt with you, we feel your pain, we listen to you, we will never yield fighting for your rights, because you should be treated as an equal citizen, not as a second-class citizen. And with hope, and with love, and with compassion, we will restore your rights, and I will oppose this legislation."
Further discussion? Senator Taylor. Senator Taylor is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate. It's not without a little humility that I stand here today to actually discuss this issue that, for all intents and purposes, it's not something that, quite frankly, I think I have the right to be standing here talking about. And some people might be offended by that, but I think it speaks for itself that I'll never have to make that decision for myself. But there are some things related to Senate Bill 1 that I think even the people who might not agree with me would agree on this. If you are right to life or pro-life, this bill ain't good for you. You put your vote up as a green yes on this, and I don't know how you call yourself right to life. For those of us who might consider ourselves pro-choice, when you put your vote up for this, if you do that, I don't know how you do it. So then you kind of back up and you wonder why we even have the bill in front of us. And I have to admit, I've been struggling questioning my friend who's the author of the bill, trying to figure out where authorship, here's an interesting piece. Nobody's taking credit for this legislation. Not one time have we asked who came up with this language. It's always, well, somebody else did it or somebody. If it's such a good piece of legislation, take ownership of it and say, I did it. But I have figured out something, and this is where I'm going to focus my comment. We should all be scared. See, because I want to go back to the Supreme Court making this decision to kick these abortion rights back to the states. See, the decision under the Roe case did not force Indiana to accept abortion as a law. It didn't do that at all. What it did is it established through scientific information, testimony from witnesses, when viability was. And then it said, now, states, based on this viability, go back and make your laws. So you had states like Indiana that might have 20 weeks. You had states that might be a little bit less conservative that might have 22 to 24 weeks. But they never said, they never said prior decisions were bad, we're just going to give you guidance. And here's where the rubber meets the roads, folks. Under this decision, the Supreme Court of this country took away a constitutional right from women and said, we're not just going to take it away, we're going to allow different states to take it away. Depending on where you live, you may or may not have a right to your own bodily autonomy. That's what they said. But here's the important thing. Do you think that's where it's going to stop? What if the Supreme Court said, in the case of Plessy versus Ferguson, that the Supreme Court made a bad decision? That separate but equal is not fair in the United States of America. And because they made that decision, we're going to kick it back to the states to have their own hodgepodge of laws. Some people grimace when I say that because that was racially motivated. But I'm going to give you something else that we all might be understand. What if Justice Alito, in his decision for gun rights and interpreting the Constitution to say that every person has a right to bear arms, which was a constitutional, he said it, for those of us who are gun carrying, permit carrying, if you're a member of the NRA, what if the Supreme Court determines that that constitutional right that Supreme Court case gave you was the wrong decision? Are we going to come back to this body based on that decision by those Supreme Court justices and say we are going to take the right to bear arms away from Hoosiers in the state of Indiana? No, we will not. Don't fool yourself. But see, Clarence Thomas gave us a hint, Senator Glick. He gave us a hint, didn't he? He said, not only did I believe that they made a bad decision in the Roe case, here's a couple more for you to take with you. Obergefell, bad decision. Didn't he say that? There was another case that he actually said he didn't like the decision. Griswold. Didn't he say that? That's a hint for you. But you know what he left out? He left out the only case that helps me, him, some of my friends, some of your family members. That was the case that allowed me to marry my beautiful wife, who happens to be of a different race. Because, see, Indiana didn't have a law for that. So in 1962, and I know the couple, the first interracial couple to be married in Indiana, I know them. You know why I know them? Because we had a help group when I got married. It was so tough. We had to have a help group. And I wonder what we would do if this same Supreme Court came back and said, Senator Taylor, Clarence Thomas, that 70-year precedent, we're going to take it away. I wonder what we would do. Do you think we would have a hodgepodge of decisions? You know why we wouldn't? Because it just ain't right. It just ain't right. You know it. I know it. We let this Supreme Court get us in a pickle now where we're going to have these hodgepodge of cases. And by the way, the two justices who voted in favor of this actually said during their testimony that it was the law of the land. So for those of you supporting might be upset, I agree with my colleague, Senator Young. I can't trust this court because they didn't tell the truth. They said this is the law of the land and we shouldn't mess with it. And less than 2 years into their actually appointment, they changed. That's all that happened. And so they gave us this carrot and we came back here and we bit the carrot to separate us, all of us who love each other in this chamber. We've had fights. We've had people stand up and argue with each other in ways that it tears at me. My dear friend, he knows it. I call him, and just to see how he's doing. I had to block one of my friends from a crowd out there just because 9 people decided to change we could stop it today. Vote this down. Tell the country that we will no longer be separated by all your ideologies and all of your theories on how we're supposed to live. Because daggone it, in Indiana, we are doing just fine. Just a little tidbit before I sit down. For those of you who might support this legislation, Texas did this. Actually, Texas did this, and they did it through an automatic thing. You know what this did? What do you think abortions went down in that state? This is amazing to me. For those of us who want to support this legislation because you think it's going to protect life, 10%. But you know what they did in one of the school districts that cut down abortions almost 50%? They opened up sex education. They gave the children prophylactics and contraceptives. They taught women on how to make sure that their body is ready for childbirth. We don't have to fight this battle amongst ourselves. We know what we can do. Don't destroy our relationships with this legislation. Don't hurt yourself. Don't hurt your constituents. And I asked you to consider, it wasn't our fault what the Supreme Court did, but it is our fault if we pass this legislation.
Further discussion, Senator Yoder. Senator Yoder is recognized to speak on the motion to concur.
Thank you, Madam President, members of the Senate, colleagues. I've had people say, how did we get here? And I will give you a very abbreviated version. In 2016, we learned that you can grab a woman's privates and she gets silenced, but he becomes president. In 2018, we learn of a non-consensual assault and she gets threatened and he gets confirmed onto the country's highest court. And today, we are considering if a rape victim has the right to abortion care and she only gets 10 weeks and the rapist might get a child. It is hard for me to articulate how it feels to stand before you in this chamber again and plead with you to let my daughters remain full people, to let your daughters, wives, and the people you serve, the people standing on the other side of that glass, live their lives with liberty, with freedom, with full, unapologetic humanity. We shouldn't have to ask for control over our own bodies. Our autonomy should never be in doubt. But here we are, again. Senate Bill 1 is an atrocious piece of legislation. At its core, it strips women of the fundamental right to control their own body and constitutes a massive overreach into private health care decisions. This is state-mandated pregnancy. State-mandated pregnancy. There is no laws on the books in Indiana saying you have to get an abortion if you don't want one. But we are about to enact a law that forces women to stay pregnant and to give birth. There are no words to describe that hypocrisy, and no speeches can capture that despair. When we call it a total ban, you correct us, and you say there are exceptions. And technically, there are, but not really. At every turn, we are treating all women who get abortions, even little girls who are victims of rape and incest, as criminals. 10 weeks is barely enough time for a woman to know she is pregnant and to schedule an appointment. 10 weeks is certainly not enough time for a young girl whose period is still irregular to know she is pregnant, to understand rape, and then to find time to find a compassionate care provider to schedule an appointment. Little girls who are just figuring out how their bodies work will be forced into pregnancy, forced to carry the baby of their rapist, their stepfather, their grandfather, because the Indiana legislature is making it so. There's no scientific reason for 10 weeks. It's not a trimester cutoff. It's not viability. It's not current law. This is a number that sounded merciful enough for Republicans to message on, but could still force as many people as possible to give births to babies made in blood and violence. Even abortions that are legal, we are treating as criminal acts. As proposed, this bill strips licensure for freestanding regulated abortion clinics. Why? To make abortions harder to access. This bill strips criminal penalties for doctors, but still requires them to lose their licensure for their livelihood if they perform an illegal abortion. Why? To make them second-guess their care and themselves, even decisions necessary to save a woman's life. Over the past 2 weeks, we've witnessed a disturbing pattern. Despite its unwavering, ego-driven intent to pass this drastically unpopular forced birth anti-freedom legislation, this body routinely failed to advance the many amendments that this side of the aisle have proposed to ensure women have access to housing, food, basic goods during and after their forced pregnancy. One of the most disturbing ones to me has been the failures in the House and Senate to pass legislation to protect the access to contraception in Indiana state law, and the dogmatic defense of resource pregnancy centers. Every single one of us in the chamber knows that abstinence-only counseling and policy isn't working and isn't realistic, although we won't say it out loud. SB 1 is not about reducing the number of abortions. If that's true, you would have voted to protect contraception. You would have voted to expand access to birth control. You would have mandated sex education years ago. You would fully and firmly advocate for places like Planned Parenthood, which provides comprehensive health and family services and planning resources. But we didn't. You didn't. So what does that say? I've said it before, but it bears repeating, because it's about control. It's about power, it's about fear, it's about sending an implicit but undeniable message to Hoosier women that your value is in your ability to get pregnant and be controlled by men. The bill's House committee, it was assigned to courts and criminal code, and that says all you need to know about it. It's not compassionate. It's not pro-life. It's pro-punishment. Punishment of women who dare to live as freely as men. Punishment of the healthcare workers who would dare to provide care for them. Punishment of prosecutors who base their idea of a crime on legal precedent rather than their personal beliefs. Here's the truth, plain and simple. A world with access to abortion is the only world where there can possibly be equality. Otherwise, women and women only bear the consequences of this draconian piece of legislation. In the cases of rape and incest, many girls will bear the consequences of a decision made by someone else and forced upon them. That is not justice. That is not liberty. It's not close to either. I want to believe we're more compassionate than forcing victims of rape and incest to give birth to their attacker's baby. I want to believe we have the humility to understand that we will never be able to legislate a blanket solution for this issue. I want to believe we have the grace and mercy not to pass this law. We heard the author of the bill say that this bill forces pregnancy and forces birth. That forced pregnancy is the lesser of two evils. Who are we? We are ranking rape and incest of a child? To those in this chamber who have given birth, remember how you felt in the months of anticipation leading up to that labor. Not just the physical aches and pains, but the fear, the panic, all the times you laid awake and wondering how you would get through it. And that's how I felt at 34. Imagine this at 9 years old. Imagine this at 15 years old. In a state with the third highest mortality rate, dismal availability of specialized OBGYN care, and no real pregnancy accommodations, there's no reason to believe a forced pregnancy is the lesser of two evils. For some women, this becomes a death sentence. We've heard a lot of talk about God recently, about carrying out God's will, about giving account of our lives before God. And if that's true, I say, okay, fine, let God judge me. Let God judge us for our choices at the end, but not you, not the people sitting in this chamber. We are not judge, jury, and executioner. It's not yours to forgive me, and I refuse to believe any God who would want a woman to carry her attacker's child. That God would believe that mercy for rape and incest victims should not expire at 10 weeks. And I refuse to believe any God would want us to decide who is worthy of mercy. Our job on this earth is to love each other, to help each other, to make our way in this world with all the grace and dignity and freedom with which we were bestowed. That is the principle that should guide our governance, that should guide how we serve Hoosiers. It is ludicrous that this is where we're going to decide where government needs to get involved in people's life, that Hoosiers on their own need to find housing and food and childcare and good jobs and a life worth living. But this is going to be your line in the sand? Here, forced birth is the moral imperative, but pregnancy accommodations, meh, those will be optional. We are not arbiters of God's will. We are elected representatives, and our job is not to pass a moral judgment on a subject so dependent on individual faith, circumstances, and conscience. Our job is to represent the people we serve, which we're doing a damn poor job of right now. We know that Hoosiers want this legislation to be defeated. We know what this bill means, and we know what Hoosiers want. We know that this bill will drive healthcare workers away. We know it will drive Hoosiers out of this state, and we know that this bill will kill women. And I'm begging you, please, let's legislate this on the basis of what we know, rather than how we feel. Let's talk in concrete terms about what your yes vote means. A yes vote is a signal to doctors that we don't care about their medical expertise. A yes vote is a vote for the government to insert itself into a woman's most personal, most private healthcare decisions. A yes vote for the men in this chamber is a vote that says a woman is less than you. Less free, less autonomous, less human. I'd consider what your yes vote means, and I hope you consider it strongly. And I hope you keep Kansas in the back of your mind, as well as the reasons you came to serve in this body, because your voters will see your yes vote, your voters will remember, and your voters will hold you accountable, hold us all accountable. Lastly, and most importantly, to the women who sit here, to the women watching, to the women we work with, and to the women sitting with the media and those who are standing on the other side of that glass. I am so deeply sorry. I'm sorry you have to be here, and I'm sorry you have to carry the burden of this. I'm sorry we're fighting an old fight again, and that we've ignored your voices as we take away your rights. Today, a yes vote will be a setback, 50 years. Setback, but not defeated. Defeat is not an option. Defeat is not in a woman's vocabulary. History knows we will triumph. If it takes 50 years, 100, or 200 years, we will keep going. And Senate Democrats stand with you, ready to defend your rights, ready to guard against government overreach, and ready to ensure that all people are able to live the lives they want to live, lives of liberty and freedom, and we will not go back. A no vote is a vote for liberty, for freedom, for recognizing a woman's autonomy. Please vote no.
Further discussion, Senator Brown. Senator Brown is recognized to speak on the motion to concur.
Thank you, Madam President. Distinguished members of the Senate. This bill is the culmination of so many hard-fought battles in the defense of life in the womb. Those of us who have advocated for the laws we currently have always pushed for better health care for both mothers and babies. But until we all recognize the humanity of every baby in the womb, we have a long way to go. To all the doctors, particularly the OBGYNs who testified in favor of more abortion access, I can only say, do your job. That is, follow your training to take care of two patients, the mother and the baby. Use the resources of your hospital system and this state to offer women total care for themselves and their baby. To the women who have bemoaned the fact that their daughters will have less health care than they do, I say, I hope my daughters and granddaughters recognize that to bring a life into the world is a gift. It is the ultimate unselfish act, an act that is exponentially returned with love. Don't we want a society that values all human beings? And what about our sons and grandsons? What lessons have a culture of abortion on demand taught them? That they have no responsibility for their actions unless the mom wants to keep the baby? We've conveyed that men get no say in preventing a violent choice. The future must include raising responsible men to be responsible fathers. Fathers are as important to the life of that child as a mother. Our poverty and crime statistics bear that out. But a culture reliant on abortion has absolved men of responsibility and allowed women to be abandoned, left alone without the support she needs. We've done this under the guise of choice. That if she only chooses to end the life in her womb, then she won't need a net of support around her. What a terrible choice to lay on a woman. Reproductive health care is the ultimate oxymoron. Many of my colleagues in this chamber have voted against making sure a woman receives all the information she needs in a safe health care setting. Many have said they are pro-life, yet they want to allow abortion for others. I believe my colleagues would rise to the occasion if a pregnant family member came to them and asked for help. Why don't we ensure that all Hoosier women have the support system that our own families can provide, so a woman doesn't have to choose between bringing a child into this world or paying her rent or keeping a job? I know some of my colleagues here have been warriors for these babies, and women are disappointed because we won't save every baby from an untimely death. I too am heartbroken because we all believe that every life matters. But I know that what we are doing today is just the beginning. Our actions today will save so many lives. When we convene in January, babies saved by this law we pass tonight will be far into the development in their mother's womb, with hair in their heads and kicking playfully as they respond to their mother's voice. We will always have more work to do because we need to make it unimaginable to end an unborn baby's life. As we ensure that women have every resource and support they need to bring the ultimate gift of a beautiful baby into this world, our job is not done, and the next phase of our work is just beginning. We need to empower women and protect life. We can do this by passing this bill and providing the necessary services that support mothers and their babies. Through our actions and support, women will know that we love them both. Please support this bill.
Further discussion. Senator Glick, would you like to close?
Madam President, members of the Senate, I appreciate the passion, the emotion we've seen tonight, the views of all the members of this chamber. I remind you that this is a part of two bills. Senate Bill 1, Senate Bill 2 provides a number, as a package, a number of different assistant measures. Not only do we go into these decisions, which we have concentrated on in Senate Bill 1, but we've provided some financial mechanism to assist these people, these women who have children. Those of us who sat through over 8 hours of testimony and rules, I sat through the hearings over in the House. Throughout them, we had person after person come forward and say, I would not have chosen an abortion if I'd have had the means or the opportunity to do something else. Senate Bill 2 goes a long way to assist young people and people without means to avoid that choice, that draconian choice in the future. And that's what we're working to. One of my colleagues, or several of the colleagues, have said, why are we rushing into that? Why are we going forward? Because in 2021, 8,400 lives were lost to abortion. And you can color that any way you want. We will not stop every single one of them. What we can try, and we can move forward. There's been several quotes, and I have deliberately steered away from the concept of God and the choice of my religion over your religion or your beliefs. But I direct you to the language of the Constitution of the State of Indiana, Article 1, Section 1. We declare that all people are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. I submit to you that they are listed in an order, and in an important order. Liberty and pursuit of happiness will never exist if there is not life. I ask you to support and to join me in the support of Senate Bill 1 and in the concurrence. Please vote in the affirmative. Thank you.
The motion to concur is placed on its passage and machine is open. Senator Toms, to explain your vote. Yes, Senator Toms recognized to explain his vote.
Thank you, Madam President, Senate. I was hoping for a pro-life bill. This is not a truly pro-life bill. It doesn't protect all the babies. So my no vote in no way has anything to do with most of the no votes that we hear tonight. My no vote is because this bill does not protect these unborn babies, all of them. This bill, 44 pages, the word abortion appears in it 177 times. Termination 8 times. Nowhere in there does it mention babies or protecting the unborn children. Nowhere. So I'm voting no on this bill. I would like to see us do a real, true pro-life bill that does protect each and every baby, unborn child. Thank you.
Senator Alting. Senator Alting is recognized to explain his vote.
Thank you, Madam President. As members of the Senate, you know, I've been privileged to be an elected official 27 years and defending women's rights, both as a city councilman in Lafayette and in the Senate, carrying the pregnancy of women in the workplace. The hate crimes bill, where I put specific women on a fine line in there. and co-authored with Senator Breaux equal pay for women for the last 10 years on her bill. But the 10 weeks in this is just not enough. It's just not enough, particularly for women in poverty, who I know, women of color, minorities, and others, victims of rape, incest, and women of intellectual disabilities. It got worse in the House coming back to us.
Senator Alting, 1 minute.
Thank you, Madam President. So I've never bought my religion in it. I've just kind of looked at the facts, but I just wanted to explain my vote. Moments we are away from history. And in my heart and in my soul, I know you feel the same way, but I feel like I'm on the right side of history. Thank you, Madam President, and thank you, my colleagues in the Senate.
The machine is closed. Clerk will tally the roll. Roll call shows 28 ayes, 19 nays. The motion to concur is passed. Secretary will inform the House of the passage of the motion to concur. Are there further messages? Anything? Is there further business to come before the Senate at this time? The chair recognizes President Pro Tem Bray for a motion.
Thank you, Madam President, members of the Senate. This time I move the Senate do adjourn until the fall of the gavel.
The questions on the adoption of the motion,
Excuse me, recess until the fall of the gavel. My apologies.
The Senate is in recess until the fall of the gavel.